Yes,
Well,
Mr. Tara.
Malad, I am seeking leave from this court to move an unlisted anticipatory bail, Malad, for today. Malad, the urgency is on 28th, I was served with a summon notice to collect many documents which I was collecting. Unfortunately, this morning, again, through WhatsApp, my lord is aware, through WhatsApp, summon is no more recognized. And it is not source of summon in terms of latest apex court judgment, my lord. So has issued the summon through WhatsApp to me to appear today, my lord. So that is the great curtailment of my liberty, my lord. Kindly see this. So kindly, madam,
Okay, we'll take it up. We'll take it up. When can you bring it?
well, just filing is being done
So
at 2 o'clock.
After 2 o'clock.
At 2 o'clock.
Yeah.
I'm deeply grateful, my lord.
May I please, Lordship?
Yes.
May I make mention, my lord? One criminal petition has been pending, but not listing for so long.
Mhm.
It is an urgent, my lord.
What
Therefore,
urgency?
I have sought for
No, what
posting
urgency-
tomorrow.
what
Urgency is
urgency?
that, my lord, the business account
Hmm.
of the petitioners has been, my lord, held by the bank authorities.
When did they do it? When did they do it?
Tomorrow, my lord.
No, when did they do it? When did they free? I mean, business accounts was freezed or what?
Yes, please.
When?
Since, my lord, August.
Since August.
Yes.
So what is the urgency now? So many months have already gone. What did you?
My lord, after issuing notice on 20 August by this honorable court, this criminal petition is not listed again. Therefore, my lord, this may be taken up tomorrow to see the steps, my lord.
Okay. Okay. Tomorrow.
Oh, nice.
My please, Your Lordship.
Yes.
My Lord, item 23 and 24.
23 and 24.
Yes, these are connected matters. In item 24, I'm appearing. The counsel who was appearing in item number 23, last time, the matter was adjourned because he was ill. Now we came to know that he's passed away.
Oh.
So, my Lord, since these two matters are linked together, the other counsel, Z Zaman, is the wife of this is I Ahmed.
Mhm.
So they asked me to pray, Your Lordship, for some time. Z Zaman will be appearing next time, since they're busy with the rituals.
So you were there in the case, you were not there in the case.
I'm in item 24.
You were in 24.
Yes, item 23 and 24 are linked together.
Okay. Okay.
Maybe listed after 4 weeks.
You Mr. D. Dungan
And Dungan.
and Dungan, the learned counsel, appearing for the petitioner.
Appellant in RSA 12.
Appellant in RSA 12 of 2023, right? 2023. She submits that the counsel, learned counsel, appearing for the petitioner in RSA 11/2023 is seeking some time due to some personal difficulties. Let the matter fixed on when do you want?
After 4 weeks, my Lord.
Let the matter fixed after 4 weeks. Any date can be given?
Lordship, no particular
Maybe
date.
sometime in the first week of February.
My Lord.
Let the matter fixed on 6th of February. 6th of February.
6th of February, my Lord. Oblige.
May I please, my lord?
Yeah.
My lord, I beg to mention item number 3, my lord.
Item number 3.
3, my lord. Kindly matter me adjourn for today, my lord. The leading counsel is out of station, my lord. R. Ingo.
Okay. Mr. So-and-so appearing on behalf of
R.
the
Ingo.
leading counsel, Mr. R.
Ingo.
R. Ingo. You have indicated
Yes,
the
yeah.
other side
I have informed.
with the consent of the other side. Praise for the matter to be listed on
After 3 weeks, ma'am.
the 3 weeks. So let the matter fixed on 29th of January.
January, ma'am.
29th of January.
My lord, interim is there, my lord.
Interim order so passed earlier shall continue till the next date of listing.
Deeply obliged, my
May I please, my lord?
Yes,
My lord, I beg to mention item number 2, my lord.
yes.
My lord, the leading counsel for a petitioner, B. Pichai, is some personal difficulties, my lord.
When do you want?
After 3 weeks, my lord.
Mr. So-and-so on behalf of so-and-so. Let the matter be listed on 30th of January.
Yes.
30th of January.
Obliged.
Lordship, I am to mention item number 18.
18.
On behalf of the respondent, I have taken the consent from
You
the.
are appearing for the petitioner?
Yes.
MS So-and-so appearing for the petitioner, and Mr. So-and-so, the Learned Counsel appearing for the respondent, submits that due to some personal difficulties, the matter may be listed after
2 weeks.
2 weeks.
There's an interim, sir.
Let the matter be fixed on 9th of January.
Lordship.
9th of January.
And Lordship, we may kindly be allowed.
Interim order may be
Interim
continued,
order
sir.
so passed earlier shall continue till the next day.
We may be allowed to file a reply in the meantime on behalf
In
of.
the meantime, you can, you can always file that. In the meantime, the respondents will file their affidavit in reply to the affidavit in opposition filed with the petition.
May your lordship, I beg to mention item number 17, your lordship.
17.
Conducting counsel for this matter, K. Lolin is out of the station, your lordship.
Okay, MS So-and-so appearing for the, you're for the petitioner,
Yes, your lordship.
submits that Mr. Who is out of station?
Yes.
Who is out of station?
Conducting counsel, K. Lolin, your lordship.
So Mr. K. Lolin, the conducting counsel is out of station. Praise for, when do you want it?
After 3 weeks, your lordship.
Praise for 3 weeks.
And there's an
time.
interim, your lordship.
Praise for 3 weeks, let the matter be fixed on 16th of January.
And there is an interim, your lordship.
The
There is an-
interim order so passed earlier shall continue till the next date of listing.
And also, item number 20 to 22.
22,
22.
22.
Yes, your lordship.
22 is
20 to 22, yeah.
20 to 22.
Yes,
22.
continue.
What happened in this?
Same prayer, your lordship.
Same prayer. Same prayer. 20 to 23. You can list it on maybe on 16 only.
Obliged.
Item number 8.
May it please your lordship. Your lordship, the item number 8 and 9, both the matter is to be placed before my lord, the bench of justice B. Habu, my lord. Because the earlier,
Yes, earlier passed the order.
yes, my lord, both the matters were withdrawn before this honorable bench, my lord.
Okay, this item number so and so. Mr. T. the Learned Counsel, Learned APP for the state submits that the matter was listed before a coordinate bench earlier. Accordingly, we praise for the matter to be listed before the same bench. Let the matter be listed before the appropriate bench.
Yes, sir.
When
My lord, the bench is available only, my
bench
lord.
is available, so let the matter be fixed tomorrow.
Yes, my lord.
Tomorrow before the appropriate bench.
Yes, my lord. Obliged, my lord.
Item number 10.
May I please, my lord? My lord, I am praying for making the interim absolute, my lord.
Why should I make it?
My lord, basically, my lord, the last time when the interim was granted, it was not granted on the ground of procedural lapses. It was granted on the ground of merit of the case, my lord. Because in the FIR itself, it was clearly,
No, let us see. I mean, what is there in the CD? I mean, what is there?
Yes,
I mean, if there are some other materials, something. Mr. Louis,
Lordship, here we received the.
he has appeared, and he's
appeared, statement
he's cooperating with the investigation.
Yes, Lordship. And I have no objection, Lordship, if
Okay. You heard Mr.
B. Nyarus.
B. Naras, the Learned Counsel appearing for the accused applicant. Also heard Mr. D. Loy, the Learned PP for the state. This is an application under section 482 of the BNSS, praying for pre-arrest bail to the accused applicant in connection with Papu Hills Police Station case number 108/2025 under sections 93, 94, 146, 143 bracket 5 of BNS 2023 and read with sections 75, 79, 81 of Juvenile Justice in bracket care and protection of children in bracket complete Act 2025 arising out of the FIR dated 22/11/2025 full stop. The allegation as narrated in the FIR is that the wife of the accused applicant lodged a missing report regarding two children before the officer in charge of Papu Hills Police Station. It was alleged that they were later traced from D sector, Naharlagun, and produced before the Child Welfare Committee in bracket CWC bracket complete full stop. After receipt of the FIR, Papu Hills Police Station case number 108/2025 was registered under aforementioned sections. Full stop. While in order dated 5/12/2025, the coordinates bands of this court has already granted interim pre-arrest bail to the accused applicant. The learned counsel appearing for the accused applicant submits that in terms of the aforesaid order dated 5/12/2025, the accused applicant has already appeared before the investigating officer and got his statements recorded. Full stop. In view of the aforesaid, he submits that since he is cooperating with the investigation and has already appeared before the IO, the interim order so passed earlier should be made absolute. Full stop. Mr. D. Loy, the learned PP, submits that in terms of the aforesaid order, he has already the accused applicant has already appeared before the police station, and he's before the IO, and he is cooperating with the investigation. Hence, he doesn't have any objection if the interim pre-arrest bail is made absolute. Full stop. Having heard the counsel appearing for the respective parties, this court is of the opinion that the interim order so passed earlier should be made absolute. Accordingly, the interim order so passed earlier by divide dated 5/12/2025 is made absolute on the same terms and conditions as mentioned in 5/12 in the order dated 5/12/2025. Accordingly, this instant pre-arrest bail application is disposed of as allowed.
Next.
Item number 11.
My lord, same order can be passed. Yes,
You
my
know the
lord.
same thing.
Yes, my lord.
Arising out of same affair.
Same-
Same affair, same police station, and applicants are husband and wife, my lord.
Okay. Same counsel also.
Deeply.
So disposed of.
Item number 12.
Lordship, as per the earlier direction of this court, I have appeared before the concerned IO on 16th of
Yes,
December.
Mr. H.A.
Yes, my lord, he has produced the relevant document in connection with the relation to the seized vehicle, my lord, and he has undertaken to cooperate with the investigation. And so far as my lord, the statement is concerned, that is not required as of now, because your lordship, he was directed to produce the relevant document only.
Okay. Heard, Mr.
A. Saxena.
A. Saxena, the learned counsel appearing for the accused applicant. Also heard Mr. T. Ite, the learned APP for the state. This is an application filed under section 482 of BNSS 2023, praying for grant of pre-arrest bail to the accused applicant in connection with Itanagar PS case number 102/2025, registered under sections 111 in bracket 2, bracket small b, bracket stroke 3, bracket 4, all brackets, bracket 3, bracket 4, bracket 5, stroke 317, bracket 4, stroke 336 in bracket 2, stroke 340, bracket 2, and 61, bracket 2 of BNS 2023. The gist of the allegation as alleged against the accused applicant in the FIR dated 10/1/7/2025 is that an organized interstate criminal racket is involved in buying, stroke, selling, stroke, transporting, trafficking of various vehicle, operating in Delhi as well as in this region. It was also alleged that several vehicles from the other regions have also been found and recovered by police in the in connection with the incident case. It was alleged that from the possession of the accused applicant, one Toyota Fortuner vehicle was recovered, which in fact on investigation shows that the concerned vehicle was involved in a police case pending in Delhi. Full stop. On receipt of the FIR, Itanagar PS case number 102/2025 was registered under the aforementioned sections. Full stop. By the order dated 11/12/2025, this court has allowed the accused applicant to go on interim pre-arrest bail. Full stop. For pre-arrest bail, directing the accused applicant to appear before the investigating officer within a period of 10 days. 10 days of passing of the aforesaid order dated 11/12/2025. Full stop. The learned counsel appearing for the accused applicant submits that the accused applicant has already appeared before the investigating officer in terms of the order dated 11/12/2025 and submitted the required documents as sought for by the investigating officer. Full stop. Mr. T. Ete, the learned APP appearing for the state has also confirmed that that the accused applicant has already appeared before the investigating officer and cooperating with the investigation. Full stop. In view of the aforesaid submissions made by the counsel appearing for the respective parties, this court is of the considered opinion that the interim order so passed earlier should be made absolute. Accordingly, the interim order so passed on 11/12/2025 is made absolute on the same terms and conditions. Full stop. In view of the aforesaid finding, this anticipatory bail application is disposed of as allowed.
Oblige, Your Lordship.
Item number 13. Please, my lord. My lord, in this matter, I couldn't take a step upon the respondents within the allotted time. And subsequently, I tried to take a step, but registry didn't permit me. So I pray your lord.
You would like to take fresh steps or what?
Yes, my lord.
Fresh steps?
Yes, my lord.
I heard Mr. So-and-so, the learned, your name?
D. Laji.
D. Laje.
Laji.
Laje. D. Laje, the learned counsel appearing for the appellant, right?
Appellant.
Appellant submits that due to certain difficulties, he could not take the steps for issuance of notice on respondents. Full stop. He prays for some time to take fresh steps in the matter. Prayer is allowed. The learned counsel appearing for the appellant shall take steps within 3 days.
Yes, ma'am.
We take steps for issuance of take steps for service of notice on respondents within 3 days by way of speed post.
Yes, ma'am.
Correct? Speed post. Let the matter be listed when?
After 3 weeks, madam.
Let the matter be listed on 16th of January.
16.
It will do? Or you need some more time?
It will take some more time, madam.
Okay, well, many responses are there.
Yes, madam.
So we'll fix it on 30th of January.
Yes, madam.
Let the matter be fixed on 30th of January.
Not the blame. Item number 14.
May I please, my lord? My lord, we have not filed our affidavit as yet, counter affidavit.
Okay, you would need some time. Why,
Yes.
why didn't you file it?
My lord, we have not received our written instruction as yet.
You are appearing for whom?
Bank, respondent bank.
Respondent bank.
Yes, my lord. Respondent number 1 and 2,
Respondent 1 and 2. Okay, you are MS?
M. Karbak.
So and so, learned counsel appearing for respondent number 1 and 2 submits that that though she has received the instructions in the matter, but could not file the affidavit as yet. So prays for some more time to file the affidavit. Prayer is allowed. Let the matter be fixed on when
My lord, 3 weeks time may be given.
16th of January will do.
Okay, my lord.
Let the matter be fixed on 16th of January. In the meantime, the learned counsel will file their affidavit in opposition in the instant matter.
Lordship,
Deeply
there is an interim order also. That we
Interim
continue.
order so passed earlier shall continue till the next date of listing.
All right.
Deeply obliged.
Item number 15.
Your Lordship, this instant case is jointly filed criminal petition. Here settlement has been done, Your Lordship.
What were the allegations?
Allegation, Your Lordship, charges have been framed under section 323 and 354 of IPC.
Where is the FIR?
FIR starts from page number 17.
Page 19 is a type copy.
Yes, you have said. Page 19 type copy of the FIR.
So you have filed jointly.
Yes, yes. On dated, Your Lordship, this Honorable Court directed this matter for mediation also. And
Mediation failed or what?
no, in mediation took place on 21/11/25, wherein both the parties appeared and they mutually agreed to settle this matter.
Mediation report hasn't come.
Yes, it's there, Your Lordship, in the.
Is there?
Yes, yes.
Where is the court's order, initial court's order? Which date?
Court order for your for mediation, Your Lordship. Order dated 30/07/25.
But these are all non-compoundable offenses.
Yes, Lordship, in mediation, only comparable offences can be settled.
How
Lordship.
this mediator has passed this order then?
Lordship, actually, Lordship, what happened that period, Lordship, they randomly they have selected and placed
Correct.
before the
They
mediator.
may have done it, I mean, might have done it that
Yes,
way.
Lordship.
I mean, otherwise, like, these are non-compoundable offenses. Mediator cannot pass any.
Your
of
Lordship, one section, section
One
323.
one is compoundable, other is non-compoundable. If there is a non-compoundable offense, I mean, in the FIR itself, like it has transpired, there is this grievous hurt. The grievous hurt is non-compoundable offense, and non-compoundable offense should not have been sent to the mediation in the first place.
Your Lordship, there are judgment which says that if the matter involves matrimonial or
That is understood,
family.
Mr. Counsel.
Yes.
What court is saying that when there is a non-compoundable, I mean, offense, court can do it, high court can do it. There are many cases, but whether mediator can do it by an agreement or whatever. Anyways, we will allow this. I mean, but thing is that like I'm a bit surprised with this because mediation, I don't know whether mediation, I mean, how come it has landed up in mediation and mediation has, I mean, reported this saying that, I mean, he has mentioned about this, that this is non-compoundable, but still he says passed an order.
Yes, Lordship.
Take down. Heard, Mr.
M. Kamo.
So and so the learned counsel appearing for the petitioners. Also heard
Elhage.
the learned APP for the state. This is an application jointly filed by the petitioners under section 528 of BNSS 2023 for quashing and setting aside of charge sheet number 04/2025 filed by Nepean NYAP and Nepean Police Station registered as Nepean PS case number 05/2024 under section 323 and 354 of Indian Penal Code 1860. Next, an FIR was lodged on 24/2024 by the petitioner number 1 against their husband and wife or what?
No, Your Lordship. Petitioner number 1 is the sister-in-law.
Okay. Sister-in-law
Yes.
against brother-in-law.
Yes.
Petitioner number 1 against petitioner number 2, alleging that petitioner number 2 had assaulted, molested, and criminally criminally intimidated and threatened the petitioner number 2 without any valid reasons whatsoever, that on the basis of the complaint, the police registered the FIR number 5/2024 under section 323 and 354 of Indian Penal Code 1860. Is there any agreement that he has?
Yes, yes.
Into
Agreement is there.
where?
Page number 63.
Page number
63.
63.
Yes.
Say onwards.
The learned counsel appearing for the petitioner submits that though the FIR was filed at that point of time, alleging certain offenses against the petitioner number 2 by petitioner number 1. The same has already been settled between the parties, as the parties are in fact in close relationship. The parties are in fact close relatives, as petitioner number 1 is the brother-in-law. Petitioner number 1 is a sister-in-law.
Yes, yes.
Sister-in-law of petitioner number 2, correct?
Yes.
Petitioner number 2, full stop. In terms of the aforesaid settlement, aforesaid agreement, the parties have in fact executed a deed of mutual settlement dated 12/12/2024, whereby the parties agreed to settle all their misunderstandings and agreed not to pursue the GR case number 12/2024 under section 354/323 IPC, arising out of the FIR, right? Arising out of the FIR dated FIR. What was the date FIR?
FIR dated 20/04 of 2024.
So and so. Full stop. In the aforesaid deed of mutual settlement, in the aforesaid deed of settlement, the parties have also agreed to file an application before the competent court seeking quashing of the pending criminal case, pending criminal case. Full stop. Full stop. In view of the aforesaid deed of settlement, the parties have filed this instant application for quashing of the FIR, dated 2011-2024.
20/04.
28 April, 2004-2024. Full stop. The learned counsel appearing for the party petitioners submit that the instant matter was in fact laid before laid before, before, this is called mediation council or what? Guwahati High Court Mediation Center.
Yes, mediation center.
Guwahati have laid before the Guwahati High Court Mediation Center, Itanagar bench, for in terms of referral to special mediation drive, that's mediation for nation, full stop. By the order of a coordinate bench dated 30/7/2025, full stop. Accordingly, the matter was placed before the mediation center of Guwahati High Court, and by an order dated 21/11/2025, the appointed mediator has settled the dispute between the parties. Full stop. Next paragraph, the mediator has in fact considered the sections, the panel sections involved in the instant case, that is section 323 and section 354 of IPC, full stop, out of which section 354 IPC is a non-compoundable offense. However, the mediator went on and after consideration of the agreement between the parties, has settled the issues and disposed of the case. Dispose of the case by quashing the FIR. Full stop. This has been brought to the notice of this court, that though there was a section which is non-compoundable, the mediator has quashed the FIR. Next, but however, they're looking into the gravity of the offense as alleged in the FIR, as well as taking into account the deed of settlement that the parties have already entered into, and the report of the mediation. This court is of the opinion that rather than going into the details of the order passed by the mediator, this court should dispose of the matter on merit, on its independent merit. Full stop. It is seen that the FIR was lost during the time of election, when the petitioner number 2 also appeared. I mean, she contested the election. Was there any election involved here?
Yes, Your Lordship.
So, I mean, she was contesting.
No, they were supporters.
Yeah, supporters
They were
lordship.
supporters,
They're
yeah.
polling, yes, lordship.
Yes.
They're the agents lordship.
During the election time, I mean,
Yes,
both the-
political differences lordship. That
I mean, petitioner number 1 is supporting petitioner number 2.
yeah, no, so
Of
they're
course
opposite. They are opposite party supporters
Okay,
lordship.
They are,
They are-
I
but
mean,
they
they are
are
supporters of opposite party.
Yes, lordship.
So that's why the tussle happened.
Yes, so they are lordship relatives actually. Two is the brother-in-law of the one lordship.
Yes, yes. We've seen that the FIR was filed, in fact, during the election time, when it seems the petitioner number 1 and petitioner number 2 are in fact supporting two different candidates. And because of certain misunderstanding, the FIR was lodged by the petitioner number 1 against the petitioner number 2. Petitioner number 2. There is also seen that the parties are, both the parties are close relatives. Being petitioner number 1 is a sister-in-law of petitioner number 2. Full stop. And they have come to a mutual settlement. Full stop. And the offenses that have been alleged are not heinous crimes like dacoity, murder, or rape, etc., which have tremendous impact on the society at large. However, the instant case involves the alleged offenses which may not have such impact on the society, but matters pertaining to personal disputes and personal matters relating to personal disputes and personal offenses against each other, which definitely doesn't have that kind of a social impact at large. Full stop.
Lordship, injury is also simple, Lordship.
Yes, the injury suffered. The alleged injury suffered is also of a very minor in nature. Very minor in nature.
This report is also there, Lordship.
Where is that?
Lordship, on the page number.
Yes. The medical report that has been annexed, the medical report which shows the injury on respondent number, injury on petitioner number 2. Petitioner number 2 is also a simple in nature. Simple in nature. Full stop. Full stop. This court, after taking into account the aforesaid factual matrix, as well as the ratios laid down by the Honorable Apex Court, in the case of State of Madhya Pradesh versus Lakshmi Narayan and others, reported in 20195 SCC 688, as well as Narinder Singh and others versus State of Punjab and other reported in 2014 6 SCC 466, wherein the Honorable Apex Court has held that the cases wherein though non-compoundable offenses are involved, which are not in the nature of a heinous crime, taking into account the subsequent events and agreement between the parties, in those cases, the FIR as well as the charge sheet can be quashed by the High Court and Supreme Court. I'll just correct it a bit here and there. High Court and Supreme Court. Full stop. Taking into account the judicial pronouncements of the Honorable Supreme Court, which squarely covers the instant case, this court is of the considered opinion that the instant matter, which has been filed jointly by the accused as well as the victim, the instant case can be closed by quashing the FIR dated
2004.
FIR dated 24/2024 and subsequent charge sheet dated 4/024 in GR case number
12 of 2024.
12 of 2024 pending before the, pending before,
JMFC Koloriang, Yapin Police Station.
MFC Colorian lawsuit.
the pending before which court?
JMFC Koloriang.
Where is it written?
Lawsuit that is in the,
JFMC,
Yes.
pending before the learned court of JMFC,
Colorian.
JMFC, come civil judge, in bracket junior division. What is the charge sheet? Page
Page number 20.
20.
Lordship, it is reflected in the lordship, the TCR lordship, which is already arrived. TCR lordship, TCR record lordship.
The judicial magistrate first class Koloriang, Koloriang,
Yes, yes.
correct?
Yes, yes.
Koloriang. Pending before so and so. Yeah, I mean, in view of the aforesaid finding, this instant criminal criminal petition is disposed of as allowed.
Lordship.
Obliged.
TCR so received to the এইটো কিমান নহব এটা মাতি দিয়ে একেলগে এইটো কেনে মাতা মানে এইটো কিয় বেলেগ কিবা কাৰণ আছে নেকি হ'ব কিন্তু মাতি
If the lordship permit, Lord, Lord, sorry to intervene. But what has happened in that division bench matter, item number 3, I have made a mention before his lordship, Justice Budia Bong. So I thought I'll inform your lordship. But what has happened inadvertently, Lord, we had given the wrong name, Lord, basically. Because wrong name of the person concerned. So I have requested and prayed because it's a joint venture. We don't have a MD of the joint venture. Is the vice president of the other constituent who is looking after the project and who would be coming before your lordship, Lord, who has been assigned.
But the party is MD there.
But there is no MD. That's what clarification I could not make before the division bench.
But now you have to change the whole thing, then you'll have to change the cost title. How do you do it?
No, Lord, this cost title as such, Lord, not.
No, see, you made a party as MD joint venture, correct?
No,
Joint
Lord.
venture is a separate company, isn't it?
Yes, yes. Lord, he's not arranged as a respondent.
Okay.
Only because for personal appearance, Lord, the name was there. Only for the purpose of personal appearance, not as regard the party as such, Lord.
Okay.
I have requested his lordship, so I thought I will inform your lordships.
No problem.
I'm sorry to intervene. Lords.
Item number 16.
Yes, madam.
Lordship, step upon respondent number 2 is still awaited.
Step on respondent number 2.
Yes, Lordship. And
You have
we may
not
be-
taken fresh steps as yet.
Yes, Lordship.
Why?
We will take fresh step, Lordship.
Okay, you take fresh steps.
Yes, Lordship.
I mean, fresh steps, I mean, order is still already there. Heard MS so and so, the learned counsel appearing for the petitioner. Appearing for the petitioner. She submits the steps in the matter is yet to be taken. Yet to be taken. So prays for some more time. 2 weeks time is allowed.
Yes, Lordship.
2 weeks time is allowed for her to the council to take fresh steps in the matter. Let the matter be fixed on 8th of January.
Okay, Lordship.
8th of January.
Lordship, and there's an interim.
Interim order so passed earlier shall continue till the next date of listing.
Okay.
So you take first steps. I mean,
Yes,
you are taking, you have the interim order.
Yeah.
So it will go on like this otherwise.
Obliged, Lordship.
You take first steps.
Item number 19.
My place, my lord. My lord, we have taken steps upon respondent number 2 through justice service, my lord. Our pleadings have been completed, my lord. So matter will fix for admission here.
You have filed the affidavit also.
Yes, my lord, I have filed an affidavit.
Third, Mr. So-and-so, learned counsel appearing for the petitioner, he submits that in terms of the order dated, in terms of the order dated 3/12/2025, the petitioner has already taken steps by the stay mode, which the stay mode, and in proof of that, he has already filed an affidavit. He has already filed an affidavit in the matter, full stop. Therefore, he submits that since service is completed in the instant case, the matter should be fixed for admission hearing.
Admission hearing.
Matter should be listed for admission hearing.
My lord, kindly matter will fix on 9 January, my lord.
Okay, accordingly, he prays the matter should be listed in the month of, in the second week of January, full stop. Let the matter be fixed on 9th of January.
No. Deeply obliged, my lord.
Item number 1.
Intermediate quantity.
Lordship, I'm not on that, Lordship. He is not complied with the notification, Lordship. Notification 2nd December, Lordship.
What is that?
Wherein, Lordship, every petitioner shall mention their antecedent, Lordship. Their antecedent, Lordship. Whether they have any criminal.
You are appealing?
They have to mention, Lordship.
Let him.
Lordship, there is one recent declaration, notification from the principal bench which says that we have to submit a declaration.
Declaration regarding what?
Regarding Lordship, that there is no similar application pending before Honorable Apex
Okay,
Court.
that you have not made.
Yes, today only we were made aware, Lordship. But also, Lordship, I have a case.
One second. Okay, in terms of this, you haven't mentioned.
Only
No,
this
no,
part.
No, not mentioned.
So you have to modify this. You withdraw
Yes,
this and file it because this has come from the Supreme Court.
Yes, Lordship.
Supreme Court has specifically asked that this, these statements should be there.
The judgment was first back in the Lordship to month of July, Lordship, but this notification come only
Only on second
Second December, Lordship.
So you withdraw this and file it again.
Lordship, matter will be listed tomorrow. We'll file it today itself, Lordship.
Okay, we'll list it tomorrow. Heard Mr. So-and-so, the learned counsel appearing for the accused applicant, also heard Mr. D. Loy, the learned PP for the state. The learned counsel appearing for the accused applicant submits that in terms of the notification dated 2nd December 2025, issued by the Guwahati High Court, the mandatory statements, the mandatory statements could not be made in the instant application, as the same was filed prior to this or after this. Could not be made in the instant application. Therefore, he prays that he should be allowed to withdraw this matter to file the application again. Again, full stop. Prayer is allowed. The instant bail application is closed as withdrawn, with the liberty to file it again. So you file it tomorrow, but today and
Today
let
we'll
list
file
it
it.
tomorrow.
Obliged, sir.
But you'll have to mention it tomorrow again, because in this order I cannot, put the words regarding, allowing of your petition for tomorrow.
We'll mention.
So you'll have to mention it tomorrow in the morning.
Obliged.
Item number 4.
May I, Lordship?
5 minutes.
Four.
Sorry.
What happened?
Sorry, Lord. Next.
Mr. Sharma, you are having some matter listed? When, which matter?
Six, Lordship.
It has come.
Lordship.
Huh?
It is there.
It is there. So we'll take it up after some time. What happened to this matter? I mean, they are not the council's probably.
Lordship.
Nikhil, no, manmula gusi gol dekho.
Oh, Megan. Item number 4.
Lordship, item number 4 may be adjourned for today. I'm for a petition. I put a petitioner. Maybe yes. For item number 4, I put a petitioner, Lordship. Matter may be adjourned for today.
Item number 4.
Yes.
Yes. Okay. You are Mr.
Yes, Sriram, Lordship.
So and so the Land Council appearing for the petitioner submits. You have intimated the other side.
Other side is yet to appear, Lordship.
Huh?
They are not reflected in the course list. Other side is not reflected in the course list.
He's not appearing. Or no one is there. Okay, on the prayer of Mr. So and so the Land Council appearing for the petitioner, let the matter be fixed on 8th of January. 8th January.
Okay. Yes.
Item number 5. My Lordship.
Oh, this is your matter.
Yes, Lordship.
You ran wrongly, huh?
Yeah.
Yes, what is this?
So Lordship, before I go go through this to acknowledge this Lordship that in Arunachal Pradesh there's a practice called customary court, and there is a law 1945 regulation, and based on that, the Gaunbura, that village authority, has decided one land dispute. That's Kebang settlement report is there in page number 54.
One second. Who are the parties?
I'm for the petitioner. Page number 54. So as per the customary practice, they usually do settlement, and before the coming of the enactment of this Arunachal Pradesh Civil Courts Act 2021, till that this practice was followed by the village authority.
You are appearing for the respondent?
Yes, my lord.
This has come for the first time over for admission.
No,
my lord.
Last time actually we had made submission, but due to paucity of time, then Lordship has given the next date.
Before which court?
Before Lordship Justice Budi Habung. Then subsequently it was put up before this Justice Kardak, but due to some unavoidable circumstances, that has come up.
This has come up for admission hearing, madam.
Admission hearing, right?
Madam.
Yes.
So page number 54, Lordship.
Yes.
So based on this customary, this report judgment, the instant petitioner, the land was given to the instant petitioner by declared in the name of the instant petitioner by stating that their distant 5th generation cousin brothers has.
Read out what is
Yes, Lordship. From a report of settlement land dispute case with order number NCH.
This was the report submitted by the subdivision officer.
No, this was a report submitted by the customary court.
Report to the subdivision.
Yes, Lordship. Here means with due respect and humble submission, I have the honor to report you that the land dispute case between
Sri Tararava, son of late Taurava, village Kyojoreng versus Sri Taluk Bialing, son of late Tade Bialing village. Mayaba has been settled by Kebang functionaries under the chairmanship of Sri Diko Baki, head GB, and in presence of Sri Lobu Nacho, PI, political interpreter, SDO, office Nacho. That after long discussion of the case, late Tariq Rava was borrowed a sum of rupees 200 only from late Tade Bialing. In this connection, late Tariq Rava had offered this personal land of Sri Tararava without his knowledge. This Tararava is the instant petitioner. So, late Tariq Rava was found illegal. Hence, as per the Kebang discussion, Sri Kandu Rava, son of late Tariq Rava, shall pay back rupees 50,000 only to Sri Taluk Bialing, son of late Tade Bialing, in place of rupees 200, only which was borrowed by late Tariq Rava. And as per the Kebang judgment over the disputed land, namely Kochok Ringo, hereafter Sri Tara Rava will be the legal owner of the said land. Therefore, this is for favor of your kind consideration and needful action. And subsequently, Lordship, next page is the...
One second. Tararava is, dispute between Tararava and Kabiang, Bailiang, right?
Yes, Taluk Bialing.
Taluk Bialing.
Yes.
Taluk Bialing.
Yes.
So Tararava and Taluk Bialing.
Yes.
Then what has happened is that Kebang has settled the issue. Then it was found out that Tariq Rava borrowed rupees 200.
Yes.
And Tariq Rava was, who is Tariq Rava?
Tariq Rava is my fifth generation cousin brothers.
The Tariq Rava was fifth generation of, this Tara Rava.
Yes, cousin brothers.
Tariq Rava has borrowed rupees 200 from late Tade Bailang. Tade Bailang is, this person's ancestor.
Yes, Tade Bialing is also relative.
This is Tade Bailing is the son of, father of this.
Yes.
Taluk.
Yes.
Taluk Bailing. And in this connection, Tariq Rava has offered the late Tariq Rava.
Son of Tariq Rava offered.
Let me understand the facts first.
Okay, yes.
Late Tariq Rava had offered personal land of Sri Tara Rava. So Tariq Rava and Tara Rava, are they related?
Tariq Rava and Tara Rava are the cousin, fifth generation gap cousin.
So the claim is that, like, in lieu of 200 rupees, the land was given to this person.
Yes, Lordship.
And without his knowledge.
Yes, Lordship.
Tara Rava's knowledge.
Yes.
So late Tariq Rava was found illegal. Hence, as per Kebang decision, Kandu Rava, son of Tariq Rava, shall pay 50,000 only to Taluk. Taluk Bialing, so and so, only which was borrowed by Tariq Rava. So land was, money was borrowed by somebody.
Yes, somebody else.
He has given somebody else's land to somebody, to another person.
Yes.
So another person's son has now come.
Yes.
He's saying that, like, this was illegal because somebody else's land was given.
Yes.
So though I have given 200 rupees, now you give me back 50,000 rupees.
Yes, Lord.
That was decided by the Kebang.
Yes, Lordship.
And Kebang was duly authorized, duly organized.
Yes, Lordship.
This is the village Kebang.
Yes,
The
village
first
authority.
customary court.
Yes, Lordship.
Yes. Then it was, it was sent, report was given to the sub-divisional officer.
Yes.
Then
in page number 55, that same order was substantiated by the SDO Nacho. There in page number 55.
Same was?
Where means, may I read, Lordship?
Yes.
Land dispute case between Sri Tara Rava versus and Taluk Bialing. Whereas a complaint was lodged by Sri Tara Rava, son of late Tau Rava, village Kyojorang Nacho, which was endorsed by Sri D. Apang, CO Judicial Kebang. As with the practice in every circle, at the circle level, there is a judicial wing in Kebang. Dapor is to SDO Nacho for the settlement by the local Kebang. Accordingly, order was issued with order number Judicial Kebang 01 2019 to 20 dated 1807 2019. The Kebang supervisor, Sri Diko Baki, issued summon to both parties to attend the Kebang on 20/08/2019. After a thorough discussion, the Kebang has settled the dispute, but no specific verdict order was issued. The SDO Nacho, with its order number September 2019, directed the Kebang to pronounce their verdict on the land dispute case. After reviewing the case, accordingly, the Kebang was held on 15 October 2019 to settle the dispute thoroughly. The Kebang has come to the conclusion that the land belonged to Sri Tararava, son of late Taurava, and late Tarik Rava wrongly gave the land to Sri late Tade Bialing, Kyojoring village for cultivation without the knowledge of Sri Tararava. Now Sri Kandu Rava, son of Tarik Rava, has agreed the Kebang decision and admit that his father unknowingly allowed Sri Tade Bialing to cultivate the land, which was a wrong decision. Now he agreed to return rupees 50,000 only and deposit the money to the Nacho local Kebang to pay Sri Taluk Bialing. And Taluk Bialing will withdraw his claim over the land as decided by the Kebang. The Kebang decision is upheld and Taluk Bialing is directed to obey the Kebang decision. The aggrieved party, Taluk Bialing, may appeal to the higher authority against the Kebang verdict and disorder. Now, same means that village authorities' order has been confirmed. Now, after this, this aggrieved party, the Taluk Bialing, has filed appeal before the
Taluk Bialing participated in the Kebang meeting or not?
Yes.
He participated.
Yes.
He participated there.
Yes. In village, they reside nearby only. It's open sacred because nothing can be hid within a radius of area. So after this, Taluk Bialing filed.
The hiding thing is different, and like we knowing the Kebang is going on and this thing, but still it may not be there.
No, he
He
participated.
would not like to be like to participate also.
He participated, Lord. Yes.
Okay.
So after this, in 2022, after gap of almost 1.5 years, means
yes,
this Taluk Bialing filed appeal before Additional District Court, Basar. And subsequently, later on, meanwhile, this AP Civil Court has come up in 2021, Arunachal Pradesh Civil Courts Act. So, as per the AP Civil Court Act, it's annexed therein, Lordship, page number 20.
Page number 20.
Yes.
So it was filed on 22.
Yes.
Second.
Yes, 2022. As per the AP Civil Court, Lordship may turn page number 22.
Page number 22, yes.
Yes. Even before that, Lordship, there is appeal provision in page number 22 that the Roman 3. Roman 3 of what? This page number 22, there's Roman 3 is there.
That is an amendment to subsection 3 of section 15.
Yes. Yes, Lordship.
The Roman 3 is like appeal provision.
Yes.
An appeal from village authority, if agreed by parties, shall be before the inter-village territorial customary court, by whatever name called, which shall settle the so-and-so, so-and-so, the so-and-so, so-and-so amount. Provided an appeal against the order of the intellectual commission of the court shall lie. Correct. What about
Yes.
that?
Now, Lordship, I would like to apprise this provided para. That's provided that an appeal against the order of inter-village territorial customary court or apex customary court shall lie before the court of civil judge junior division, the courts of civil judge senior division, the courts of additional district judge, or courts of district judge, as the case may be, as per their territorial and pecuniary jurisdiction. So here, the matter was endorsed back to the civil judge senior division, Daporijo, but the amount is of 200 rupees and 50,000. And now, Lordship may turn page number 20.
No. I mean here the appeal was filed before whom?
appeal was filed before the district and session, additional district and session court Daporejo. But they have endorsed back that too.
Because of the pecuniary jurisdiction.
No, they had just territorial jurisdiction.
What territorial jurisdiction?
That the land dispute is there in Daporejo, within Daporejo, so Upper Subansiri district. So it can be, it's there as per page number 67. That page number 67, Lordship.
Yes.
Here, case records put up on receipt from the Honorable Additional District and Session Court, Basar, Leparada, district with order number dated 02/03/2023, passed in Basar IA 1622 in Basar, Civil Appeal 1322. Same is re-registered as Daporejo Civil Appeal number 02/2023. In view of the above, issue notice to the Board of Fix. Here, Lordship, here the matter was reverted back to the territorial jurisdiction of the Daporejo. So now my issue is, main issue is here that they were supposed to dispose of the appeal first. Then they can go for de novo trial. Before that, there is need of plan. Because in village authority, there is no exact plan as per the order 4, rule 1.
Exact
Plan is need to be instituted. But here, memorandum of appeal has, means in memorandum of appeal only that Honorable Civil Judge Senior Division has decided the title. That's one issue over here. Second thing is that, apart from that, Civil Judge Senior Division has arbitrarily tried the case.
there are two things. Now, one is hearing the appeal. The other one is like taking the whole trial de novo.
Yes.
So trial de novo means the whatever materials are already there before the customary court, those material will be placed.
That's why only that order is there. No plan is there. No plan is there. So next is page number 20, Lordship.
No, the plaint will be required when the matter will be heard de novo.
Yes.
But when the matter is heard in appeal, all the materials before the customary court, those will be placed before the court.
Yes.
So that will not be a de novo kind of a trial. That will be heard as an appeal.
Yes, Lordship. That's exact my understanding. But here, instead of endorsing this to the Civil Judge Junior Division by this Civil Judge Senior Division, has arbitrarily taken up the case.
Why arbitrarily?
So that's the main issue over here. Arbitrarily tried the case by knowing that as per the section 14 of AP Civil Code. And even if we see the rule 7, order 10, order 7, rule 10 and 10B, where it's clearly stated that if appellate court finds that matter need to be revert back to endorse to the appropriate court, then they need to pass that appropriate order. But that has not been, judicious mind has not been used by the Honorable Court before this Civil Judge Senior Division. So Civil Judge Senior Division has taken up the appeal without disposing that in that appeal only, Honorable Civil Judge Senior Division has tried the case and declared a title also.
Where is the provision that it has to be sent back to Junior Division?
Yeah, Lordship, page number 20, Lordship.
Page number 20.
Yes, it's AP Civil Code.
Yes.
2021, section 14.
Page number 20.
Yes.
Section 14.
Yes. As the jurisdiction of courts of Civil Judge Junior Division, Lordship.
So dispute is about 200 rupees and 50,000 rupees.
Yes. So
It doesn't go beyond
10 lakhs.
10 lakhs of rupees.
Yes.
So it should have been endorsed to the junior division.
Yes.
But senior division has heard it himself
Yes.
and passed the order.
Yes.
That is your case.
Yes. And apart from that, means Order 7, Rule 10,
Order
B,
7.
Rule 10,
Hmm.
read with Rule 10B.
Read with Rule
10B.
10B, yes.
Yes. Power appellate court to transfer suit to the proper court.
Hmm. The civil court. CPC 9 come on. Yes.
So instead of endorsing, because that civil judge junior division is there within their nearby compound only, that court is. So instead of endorsing there, civil judge senior division has tried and disposed of the case by declaring the title. Whereas, as per the memorandum appeal, it need to be the purpose of appeal and the plain both are different thing. Here, in the memorandum appeal, they need to decide to set aside the impugned Kebang judgment, and after that, then only they should this party should file a fresh plan, because there is no plan in this case.
Yeah, there is no plan in this case.
Yes, originally there is no plan.
So that is why there is no plan. So this I mean Order 7, Rule 10 will not be applicable.
Yes, but Rule 10B.
Yeah, Rule 10B also power of appellate court to transfer a suit to proper court.
Yes.
So this is herein also
Lordship, it's appeal only because civil judge senior division is appellate.
Appellate court?
Yes.
That's what I'm saying, where an appeal against. See, here it says where on an appeal against an order for return of plaint. Order for return of plaint.
Yes, Lordship.
Correct. The court hearing the appeal confirms such order. The Court of Appeal may, if the plaintiff by an application so desires, while returning the plaint, direct the plaintiff to file a plaint subject to the provisions of so and so in court in which suit should have been instituted. What do you want to say on this?
So I mean to say is that even though if this is also appellate, civil judge senior division is also appellate forum, if pecuniary jurisdiction cross 10 lakhs, but it's about 50,000. Now it should be endorsed to civil judge junior division. Whereas they had determined this appeal only. Meanwhile, while determining, they decided title also. Only in appeal. So now.
The title has been already decided there in the Kebang.
Yes.
Kebang already confirmed it is.
Yes, confirmed. But that's in my favor. But civil judge senior division has reversed that decision.
In appeal, they have decided.
Yes.
Reversed it.
Yes.
So where is the wrong there?
Here.
Only thing is that this should have been endorsed to the junior division.
Yes, that's one.
That is one point. And the second point is it can decide the title. Why not?
No, Lordship, here the reasoning for decision is that I have not filed injunction. That's one reasoning. That meanwhile I have not filed injunction. Since I have presumption that I had made a complaint before the concerned police station, concerned CO, it's a practice over there in village level. Then I have presumption that okay, cases I had made the complaint and police will not allow them to encroach the land. But meanwhile, Honorable Court has presumed that I had not filed the injunction application because that was just the stage of appeal only. And in appeal, the Kebang judgment was stayed. Once that is stayed, then I thought it's in the appeal stage. After appeal has been disposed of, then only fresh title will be heard. So that's the practice in most of the court over here. First, customary court judgment need to be suspended or quashed. Then after that, Honorable Court will pass that you file a fresh title suit so that we can determine properly. Since as per the AP Civil Court Act, Section 18, since the Civil Procedure Court doesn't apply to the customary court, where means they doesn't have exact evidence witness record, but on the spot, all the villagers, they attend together.
You sit where is it any?
So Lordship, here main issue is that they had not, they were supposed to dispose of only the appeal. Then subsequently after that, there is need to file a fresh title suit.
No, in all the cases, do you need to file fresh cases?
Yes, Lordship.
Why?
Because in appeal, they will determine only that any judgment, that judgment need to be suspended or quashed. And after that, there will be new facts and circumstances and new records will come up. So material facts will be adumbrated.
Remanded to because it's a new code. So
Yes.
it will be remanded. In appellate forum, if KEBA decision is quashed
Yes.
or set aside, then what happens? Like it is sent back to KEBA or like it is sent back to the, it is sent to the,
Lordship,
Civil Court.
Yes, practice over here in UPA, customary court judgment will be set aside. Then subsequently they will.
Only when the customary court judgment is bad.
Yes.
Then only it will be set aside, right?
Yes, yes.
Not routinely it can be set aside.
Yes.
If customary
Most of the cases they upheld.
Yes, they will
Yes.
upheld it. So
Yes.
once it is upheld, there is no problem.
Yes, yes.
But like if there is something, wrong in that,
Yes.
then it will be set aside and quashed.
Yes.
And once it is set aside and quashed, whether it is sent back to that Kebang or it is go to the as per the new
Here,
code.
here, Lordship, for clarity, what happened if suppose that's a first instance customary court, village authority, then what happened, they usually, if suppose, if we read section 15 clause 4, the appeal from the village authority shall lie before the inter-village or apex.
Inter-village only when the parties agree.
No, there is amendment in 2023. Agreed party can. Before that, there is agreed. But in 2023, there is amendment.
Correct.
Yes.
So, 2023 onwards,
23
you'll
on.
you'll have to mandatorily go there.
Yes, yes,
Correct.
yes, Lord.
Hmm.
So here,
It was filed prior to that.
yes,
So, they have directly come to the civil court.
yes.
Hmm.
So here, they may approach to, right now, if suppose matter is right now, then they may approach the inter-village.
No, I
That-
understood
yes.
that. Now it has come to that.
Now,
So
Lordship's
at
question.
that point of time, I mean, they did not go to the inter-village court.
Yes.
They directly come to the civil court.
Yes, yes,
Correct. Now your case is that like in the civil court, rather than endorsing it to the junior division, senior division has heard it.
yes,
After hearing that, then they have confirmed the title.
yes,
Now, they have rejected your
yes, my title.
whatever has been confirmed
Kebang,
by
yes.
the customary court,
Yes.
that has been reversed. in fact.
Yes.
Hmm.
And as
Now, so I mean, what is the difficulty in doing that?
now here, difficulty is that they had never considered the customer practice over here.
Why?
One thing is that since it's my land, someone has sold,
No, where is the customary law?
customer practice is there, Your Honor.
What is, I mean, where is
Customary
the
practice, yes, is that there is a family or community land over there.
Once civil court has come,
Hmm.
now you can't say that there is a customary practice. I mean, invariably you'll have to do that.
Lordship, it need to be appreciated by,
I understand that in the customary court, in the appellate court of customary courts, those things are there. Correct.
Yes.
I mean, now it is the civil court has come. The civil court will go by the civil court only.
yes,
Now, once a appeal has been heard from customary court, so it will be heard as per the, I mean, of course, customary law will be taken, substantive law will be that, but
Yeah.
procedural law will be the civil court.
yes, Lordship,
So as per the civil court, the matter was decided,
yes, Lordship.
and after this, after hearing the matter only, the court has reversed.
Lordship, that's why reverse reason is that they had not considered my customary, appreciation.
What is the customary appreciation?
Appreciation is that as per the practice, customary practice, someone cannot sell my land and the person who bought, that person cannot take away my land. Since the person who sold that Mr. B, how that person, someone come and suddenly can sell out my land?
Correct. So then you argue on merits, then like, I mean, I mean, your grounds, you are saying that, I mean, only this thing, no? That senior division, junior division, that is one
yes,
point. That is
yes,
one point.
yes,
That's, it should have been endorsed to the junior division.
Yes.
Because of the pecuniary jurisdiction.
yes,
Correct.
yes,
And second one is, I mean, that he has not considered your customary law.
yes,
The customary law is what you are saying that, I mean, somebody else's land could not have been given to him.
yes.
But you agreed there in the customary court.
No, Lordship, I had stated that was not in my knowledge in customary court. And
Which was not in your knowledge.
that Mr. B, C has sold my land to B.
But you agreed to give this 50,000 rupees to him.
No. The son of that,
Correct.
yes,
That you agreed before the customary court.
they had agreed. And because I have nothing to do with both the party. Both the party, for example, that person has land, his
Now,
late
did you
father,
raise any objection there?
in this regard.
Customary court, yes.
Customary court, no, there is no issue that since customary judges has determined by stating that, no, as per the customary practice, that person cannot sell my land.
Correct.
Therefore, that person should pay back their money.
50,000 rupees.
Yes, not me. So land belongs to me. Means land belongs to mine. The customary court
Correct.
has
Land will
taken-
be with you.
Yes.
And in lieu of that, 50,000 rupees will be paid.
No, I will not pay.
You will not pay, the other person
Yes,
will pay because
because-
he has wrongly.
Yes.
Hmm.
I'm not involved over there. Just without my knowledge, everything that transaction has been done within themselves. And because of that only, that third person has started claiming my land. That's the issue. Now here, subsequent issue is that as per the Honorable Civil Judge Senior Division judgment, that I had not made injunction application. That's one of the reasoning. So meanwhile, there is a police complaint also. So just they saw that there is a possession, land has been under that Mr. B's possession, but that's not like that. That's jungle land. Now, recently, in few years back, approach road has been brought up.
You are appearing for whom? You are for this Tararaba, isn't it?
Yes, yes, Lordship.
So Tararaba was the original landowner.
Yes,
So Tararaba's land was given to somebody else
yes.
by this Taluk. Taluk
By Tariq
by Tariq.
to Taluk.
By Tariq to Tarak to Talik.
Yes.
Hmm.
So therefore, here means, as per my reason for this civil revision petition is that they had illegally exercised the jurisdiction that I'm not aware about the reason why honorable judge has illegally exercised that jurisdiction. Instead of, by knowing that, even as per the order on record also, that appeal has been filed under section 15 clause 3, because as per that, there also it's written in section 15 clause 3 also, it should be based on the pecuniary jurisdiction, and amount is clear. Amount is pecuniary jurisdiction is clear. There is no dispute. But honorable civil judge junior division has arbitrarily taken up the matter, because that's the issue, Lordship. Otherwise, in most of the cases, all the judicial officers, they will start doing same thing. Then there will be conflict of interest, Lordship. So that's the issue in this case, main case. So therefore, even though this means there is a law in section 21 that jurisdiction need to be objected in the initial stage, but verbally that was submitted, but that was never taken on record by stating that civil judge senior division, since junior division is working under civil judge senior division. Now, senior division has used the discretion. So in most of the cases, if that practice is happening, then there will be interested party only most of the cases, judicial officers. So here, that's the case, Lordship. So if this has been tried in appropriate court with unbiased, means fresh de novo trial.
Basically, you're saying biased. Senior division was biased.
Yes, Lordship. It's biased. It's on record also. Because not filing an injunction is not the reason to pass judgment. By stating the reasoning that the respondent has not filed any injunction, that shows that they are not the landowner. They, as per the village record and everything, and the dispute land is in jungle. Even the witness could not come down to the town, because court is there in town, Daporijo, but the village that Kyojorang is there in Sium Circle. So those are the facts and material suppressed by this honorable, civil judge senior division, where means that has not been brought before the honorable court. So,
and if, this land is in your possession only all throughout.
Yes.
All throughout.
Yes.
Then how this dispute came later on now after so many years?
So that's dispute has come up. Reason is that in 2019, there is a flagship project called Vibrant Village Road. Once that project come up, then this Mr. B, the Tariq Rawa, Mr. Taluk Bialing, their family member, they wanted to start that project by themselves. But meanwhile, I being a landowner, I objected. Since it's my land, if you want to cut, then you have to convey me. Meanwhile, in my absence, they had illegally started that cutting and illegally constructed one kacha house. So that's the main issue. And I'm the inhabitant of that village. And that Mr. B is not an inhabitant of that village. And Mr. C, that my sixth generation brother, their late grandfather, they had sold that land to that person.
Verbal sold. Verbally, or some agreement was there.
Verbally.
Nothing was there.
Yes, nothing record is there. Nothing agreement is there. Even on this, this Kebang judgment is only the first record where that case has been brought up.
All throughout it was your land.
Yes, because it's jungle, Lordship. In jungle, what happened? Because of this Vibrant Village Road only, that's the issue. Otherwise, nothing was issue, because in most of the village area, jungle is common for some clan.
Okay. Okay, let me see what he has to say.
Well, I'm appearing for the sole respondent, my lord.
Hmm.
My lord, facts, just some facts that has been missed out, my lord. My lord, there is, firstly, this dispute has never been about 200 or 50,000, my lord. It is about the dispute, my lord, between the parties, my lord. It's not about monetary dispute. It's about the land, my lord. It's not 200 or not, neither 50,000.
Yeah, correct.
It is what, yeah, it is what the petitioner is.
The thing is, the Kabang has decided that it should be.
Kabang said something, yes, my lord, that is there, my lord. Now that Kabang was decided against me, my lord, of course. And it was before the coming
Kabang
of the,
decided against you, asking you to pay the money.
no, asking money to be paid to me, my lord.
Correct.
By his relative, my lord, relative of the petitioner, my lord.
Money has to be paid to you.
Yes, that
But
was,
you were there in the Kabang.
yes, I was there. That is not in dispute, my lord. Now, against that Kabang, my lord, I preferred an appeal, my lord. At that,
Why you preferred an appeal?
because I don't want the money. It's not about the money. It's about the land, my lord. I'm claiming ownership over a certain plot of land.
But you didn't object it to in the Kabang.
We objected, my lord. We objected, my lord.
Nothing on record.
Nothing on record, my lord. That's why we have filed the appeal, my lord. Otherwise, my lord, if we are satisfied, my lord, we would not be there, my lord. in the
Correct.
appeal.
I mean, but once you are participating in Kabang is just
Well,
a customary court. In
Customary.
the court, you didn't raise any objection. Then can you do it in the other courts?
No, those objections were raised, my lord.
No, correct. Where are the
No, my lord. My lord, there the dispute is about the title, my lord. Kabang said something that this third party, you pay something, my lord. Yes,
But
my lord.
like Keba is a customary court,
My-
right? It has all the validity under the law.
My lord, my lord.
Correct?
My lord.
So like Keba has decided something.
My lord.
You did not object to that at that point of time. There is
My lord,
nothing on record at least. There is
of
nothing
course,
on record only.
yes, because my lord, there is in the Gaumpura generally are not literate persons, my lord. Their procedure is there, my lord. It's not a very formal procedure, my lord.
But
Informal.
I mean, in your appeal, whether you have stated so.
The appeal we have raised, my lord.
Where is
Yes,
that?
my lord.
Is there?
But today, my lord, yes, my lord. What I'm
Show me in the I mean from the record that in appeal, when you filed the appeal, you stated that you have objected to the whatever the decision the Keba has taken.
my lord, I have my objection. That's why I
You know,
preferred an
whether you
appeal.
have stated in the appeal or not, pleaded or not.
Pleaded, my lord. Appeal is there, my lord. Yes, my lord. Appeal-
Whether you have pleaded or not. Show me.
Memorandum of appeal, it's at page 56.
Page 56. Yes. From there, you show me where you have stated that you objected to this.
It is more specifically the point my lord is raising. It says page 63, my lord.
Page 63.
My lord.
Yes.
Because the present dispute gave for
Which paragraph?
11, my lord. Otherwise, the grounds start from page 62.
Page 11, para 11 you read?
Yes, my lord. Page 11 gave the present dispute has arose after gave of ordinance when all the primary party, the execution of sale through its seller, purchaser, father of respondent, no more in this art. There is some malified intention by the respondent over the land for which he is applying all of so and so, so and so. My
Nothing is there.
lord. No, my lord. Basically, it says this is regarding the seller, purchases, everything that is raised because these persons are no more alive, my lord.
Correct.
Yes, my lord. Now, my lord, but
Your thing is that, only thing is that 200 rupees, right? 200 rupees has been borrowed.
it is what they are saying, my lord.
200 rupees was supposed to have been borrowed from you.
My lord.
And now the Keba decided that like the value has gone up now. So this party will pay you 50,000 rupees.
Not this person.
Not this party, the other party.
Yes, my lord.
And let the land be real. Land remain with the person who actually be, his land, it is his land only.
No, my lord.
Whose land?
It was a land of the person who sold me, my lord. This is a dispute, my lord.
No, the Keba decided that this is that land.
My lord, Keba decided, that's why we are on appeal, my lord. That's why we went on appeal, my lord. That's a wrong decision. That's why we were on appeal.
But there is no material record. You have not also pleaded for that.
My lord, that entire trial was done, my lord. My lord will see, my lord. Firstly, that regarding this.
Now you show me from your pleadings before the pleadings in the appeal,
My lord.
stating that before the customary court you have raised all these objections. Before Kakeba decided that.
My lord, before the customary court, before the Gaon Bora, it's verbal only, my lord.
Correct.
Verbal is
But
done,
they-
my
I
lord.
mean, there
No,
is-
my lord, but today we are, today, my lord, not on merit, my lord. But my lord, this, my lord will notice, my lord, this is an application under 227, my lord. This is not an appeal, my lord. My lord, what happened? We preferred an appeal, my lord. Appeal because
He's
the,
come with the, I mean, pleading, I mean, he's come with the case, that his case is that this 227 he has come because the senior division has decided a matter of his own, rather than sending it to the junior division because of.
no, my lord,
because
it
of the
is,
pecuniary division.
no, my lord, can this court today decide whether the land of the, price of the land is 10 lakhs or 50,000, my lord?
Cannot be decided.
It cannot be decided. And those issues were never raised, my lord, before the civil judge senior division, my lord. My lord will take up, firstly, since my lord, about that, my lord will see CPC section 21, my lord.
What is that? It will be.
Regarding the pecuniary jurisdiction, territorial jurisdiction, it has to be raised as the first instance, my lord. Now that order was passed in 15/5/2023, my lord, by the civil judge senior division, wherein the appeal, because the AP Civil Courts Act, my lord, it gives some, because this system is not prevalent anywhere else. So there's a special provision where on appeal, my lord, the civil judges, they can either hear the matters under the, on appeal, as an appeal, or try the case de novo, my lord. Now, when the,
But if de novo, then the opportunity has to be given to file proper pleadings.
yes, they filed written statement, evidence were adduced, trial completed, and when the decision is in my favor today, my lord, just because the
So it was taken de novo, you're saying?
de novo, yes, my lord. That order, 15/5/2023 order, they are now challenging, my lord. Can it be possible, my lord?
So it was not heard as an appeal, it was taken as a de novo.
De novo.
Is there any order on that?
There's an order, my lord.
So show me that.
They said 15/5/2023, my lord, page 50, my lord.
Page 50.
50, my lord. Annexer E, my lord.
Yeah, please read out. Where is that?
The relevant portion would be at page 53, my lord. Second last paragraph, my lord. This was heard, and then in view of the above, the civil appeal number 13 of 22 is admitted. Having considered the plaintiff arguments, I'm inclined to try the case de novo, and thus appeal petition is deemed as plaintiff, my lord. The solicitor shall re-register the civil appeal number so as title suit, my lord. And after that, the trial commenced. They filed their written statement. Trial commenced. Everything done, my lord. Now the title has been decided in my favor, man. Now today,
There are many cases has been decided by this court also probably, whether the matter should be taken up in de novo or in appeal, or appeal, as appeal.
yes, my lord, of course, that, my lord, whether it is to be taken up as de novo or, my lord, as a appeal, it has been left to the discretion of the judges, my lord, civil judges, before whom the appeal is presented, my lord. Now that civil judges exercise her jurisdiction,
Is it a correct proposition?
No, Lordship, as per the practice over here.
it's not about the practice, man, it's about the law, man.
Yes, the de novo need to be tried by filing a fresh plan. Here, it's the stage where appeal is to be determined. This order,
You have any judicial pronouncement on that?
no, but here in more.
Do you have a judicial pronouncement on that by this court, High Court, Guwahati High Court? Do you have it?
Lordship, as of now, because it's very new in this.
No, there are a lot of pronouncements have been done when the court takes up the matter de novo, and the court takes up the matter appeal. What he is saying that this court has, I mean, civil court has decided the matter to be taken as de novo matter, not as an appeal. So opportunity was given to you also.
Here, Lordship, in this case, I file a reply.
Written your reply.
In this appeal only.
Correct. I mean, appeal can be also taken as a de novo matter. I mean, is there any judicial pronouncement that an appeal, when an appeal has been filed, then the appeal cannot be treated as a plaint and like fresh plaint has to be filed? Is there any case law on that?
Lordship, I have to go through.
Well, to my understanding, it's not there, my lord.
Go and find it out. Come up tomorrow or day after. You find it out.
Yes,
That is the main issue here.
Let it be tomorrow, man. But otherwise, my lord, what is the issue, my lord, that I am raising the maintainability of the petition? Whether these things can be, my lord, raised under the Article 227, my lord, when there is an appellate provision, my lord, under the CPC, my lord, statutory provision is there. What are the powers of the, my
He's
lord?
trying to come, see, he's basically, your argument is that this court, this case should have gone to this thing, junior division, right?
Yes,
That's
Lord.
why you have filed 227.
Yes, Lordship.
That was the ground.
My lord, yes, my lord, that's what, my lord, I'm saying. Under, now, my lord, at that time, they did not raise any issue, man. And when, my lord knows, my lord, under the supervisory jurisdiction, man, when an elaborate, my lord, explanation is needed, my lord, under the 227, my lord, their errors should be apparent on the face of the record, my lord. When elaborate discussion has to be made, elaborate explanation has to be made, my lord, it's exercising the appellate jurisdiction, not the supervisory jurisdiction, my lord.
Whether it has been, this objection was taken at the initial point or not.
That was also not there, my lord.
That
Yes.
was not there.
They have never taken the issue,
You
my
have not taken that objection.
Lordship, that was on verbal, that
Well,
honorable court was, but thing is that I was presuming that it's only in appeal stage.
How can you presume it? Like, your case
Lord-
is going on before a court, civil
Lord-
court, and you presume things, and
Lord-
on the basis of that, you can
Lord-
come and submit that I was presuming that, presuming.
Just, my lord, my lord, would see, come on.
Like
That
that, Mr.
council,
May I
I was
page
the
50,
council.
my lord.
I don't
Yes,
know. I'm
yes.
saying you are the
Yes,
counsel.
yes.
But like, if you now say that, like, I was presuming that.
No, Lordship, because
That can't be a plea.
it's only the memorandum of appeal. So meanwhile, there was,
See, when memorandum of appeal was there, there's a specific order passed
My
by
lord,
this
will,
court
yes,
saying that I'm inclined to try the case de novo, and thus appeal petition is deemed as plain. Then you didn't raise any objection to that.
Though the parties were represented.
As I remember, I think this is my third sitting in Arunachal Pradesh. In my first sitting, I took up a matter on the matter like this, where de novo can be taken and where appeal can be heard. Then I have decided a case also. Then, that's why I'm asking, you come up with a case showing that, some cases should be there, but because a lot of cases have been decided by this court, Itanagar bench, saying where this, the appeal can be treated as, when an appeal can be treated, when a de novo cases will be taken, when an appeal has been filed, whether appeal plaint can be taken as a plaint or not.
yes,
Appeal, not appeal plaint, appeal memo.
yes, Lordship.
Whether that can be done or not. So now your case is that it should have been given an opportunity to file a new plaint, right?
Yes, Lordship.
That you find out, you come up with some.
Okay, Lordship, I will do.
But I don't think that is the law. If appeal memo is there and it can be decided, that appeal memo can be treated as a plaint, and when you have been given opportunity to file all those other, all other provisions are same. Witnesses can be called, evidences can be taken, you can file your objection, issues can be raised, all those things were there for CPC. Only thing is that you come up with a pronouncement where it says that you'll mandatorily that court has to give you an opportunity to file a plaint rather than treating the appeal memo as a plaint.
Yes, Lordship, I will
You
do.
come up with that.
Otherwise, based on the pleadings, issues were framed, my lord. Both the parties led evidence, witnesses, my lord. And now, after more than 2 years,
And you haven't raised the objection at that initial point of time. When the trial was over, matter was heard, now you are raising the objection, that issue. Correct?
No, Lordship. Initially, it was apprised to the honorable court verbally that because this type of issue is brought up before in some other court also, where civil judge senior division are keep on taking up the cases.
And he is raising another objection.
Yes.
227 petition, how you are filing, you'll have to convince this court also on that
yes, my
also.
lord. He has to go to appeal, in fact, my lord. That issue is basically,
Lordship, appeal is there, appeal provision is there.
The only thing then, I think you are filing this on the basis of that, pecuniary jurisdiction.
Yes, Lordship. And arbitrarily that honorable civil
He
judge
said
has.
that, Superior Court can take up the issue.
But otherwise, my lord, under section 21 of the CPC, neither the appellate court nor the revisional court, my lord, They cannot take up the issue of the jurisdiction if it has not been raised, my lord, at the earliest, my lord.
But if there is a failure of justice, because here on record,
Okay,
Let-
you bring those judicial pronouncement. I mean, you bring the case laws. We are fixing it tomorrow?
Lordship, day after tomorrow.
No issues.
Day after tomorrow.
After tomorrow, fine.
Yes,
So
Lord.
day after tomorrow, we'll take it up and finish it over. I mean, we'll not go beyond that. Because,
Yes.
Day after tomorrow is the last day probably.
Yes, Lord.
Last it is.
Rather, we should fix it tomorrow. Why not tomorrow?
That's why, my lord, otherwise I'm
Lordship,
saying that
actually, I have
tomorrow, because they have
other matter
the
fixed
last,
before other courts for tomorrow.
on the last day, sometimes it's difficult, my lord. So that's why.
Okay, day after tomorrow, we'll take it up as a fixed matter.
Yes, Lordship.
Take it up as a fixed matter.
Yes.
Heard, Mr. Swenso. Your name?
Tikipa.
Tikipam, the learned counsel appearing for the petitioner. Also heard.
This okay, my lord.
This okay, the learned counsel for the respondent. The matter remained part heard. Let the matter be listed on 24th.
Yes, Lord.
24th as a fixed matter. So you bring all those, whatever you have argued.
Highly up.
Item number 27, unlisted motion matter.
My lord, at the first place, I want to bring it on record that we have not annexed the FIR copy because we could not obtain, my lord. And if you have a genuine apprehension, you can come to the court without copy of the FIR. That is, my lord, is aware, Gurbakh Singh Sibia case, 1982 SSC 565, my lord. The para 43 is very clear, my lord. So, my lord, that part I want to make it clear, my lord. Now, my lord, here, there was a issue relating to the compensation for Ladakh to Surli Frontier Highway, my lord. Ladakh to Surli is a frontier highway road sponsored by the government of India. There, the certain discrepancies were there, my lord. One, my lord, all the officials who were involved, my lord, three of them have been suspended and one has been arrested, my lord, in this case. And I am the chairman of the compensation committee for the project affected people, my lord. So my role is very limited.
Compensation for land acquisition.
Yes, my lord.
So
now-
even the committee and there is some allegation of corruption.
There was some, my lord, I am not named in the FIR, according to them. My lord, here in this case, my lord, the media trial is going on. On the basis of this media trial, a pressure is being exerted on the Anti-Corruption Bureau to register the case, carry out the investigation. Now, my lord, kindly see.
Anti-Corruption Bureau of
State
Vigilance.
State Vigilance.
So anybody appearing?
My lord, I tried my best to communicate. It's not picking up the phone, my lord. Now here, my lord, today, my lord, I need the protection of this honorable court for a few days for the reasons that, my lord, kindly come to Annexure 6, page 35, my lord. This was a notice served to me, and this notice was served to a minor boy in my house. And I got to know this morning, my lord.
Page 25.
35, my lord. 35.
35.
35, my lord. If, my lord, it is visible.
Now, how do I know that it has been served to minor?
At home, it was delivered.
So home residence is delivered.
Yes, my lord, fine. We will not quarrel on that, my lord. Kindly read this, my lord. The intention. To so and so, so and so, so and. Whereas you are required to appear before the investigating officer, so and so, number so and so on December 24th, 2025 at 11 a.m. at the Anti-Corruption Bureau Police Station, AP Civil Secretariat, Itanagar, opposite State Legislative Assembly House, AP, in connection with the case under the investigation by the ACB in FIR number 13/2025. Whereas you are hereby summoned to appear before the IO of this instant case and to ensure compliance with the following instructions. My lord, bring a valid government ID proof to establish your identity, bank account number, PAN card, Aadhaar card, and firm license. Come prepared with documentations, and produce all relevant documents related to this case, name of so-and-so, so-and-so, so-and-so. My lord. 3, provide testimony regarding your involvement in this matter. Do not tamper, destroy, or delete any documents, electronic materials, evidence, or videos related to this case on your communication device or electronic gadgets. Now, my lord, the case has been registered. My lord, I have made a categorical statement also that my role is only package 5. And my lord, before I turn to the crux of this page, my lord, kindly come to this page. This is something which is disturbing, my lord. My lord, kindly come to page 33 for a moment.
Yes.
There was a minutes of meeting, and the organization which was spearheading this movement, this is a minutes of the meeting.
Yeah, dated.
Dated, my lord,
18.
18 December, my lord. This type copy, I am on type copy. Yeah, true copy, my lord. Digitally signed in, my lord. So, my lord, kindly see. My lord will kindly see this, the meeting. It was headed by the Honorable Home Minister of Arunachal Pradesh. And then see this, then IG Law and Order, Officers of Home Department, number 4, Executive Member, my lord will kindly mark this. Executive Member of CEC, Anya, headed by Sri so-and-so, present so-and-so, Executive Members of Anya East Coming Unit with deprived members of land compensations. Now, my lord, the cumulative decisions, my lord, will find the fact-finding committee, so-and-so, so-and-so, shall be submitted by 19 December 2025. This has been confirmed through so-and-so. Government shall initiate course of action as per findings. The meeting ended with words of appreciation from the chair to the present so-and-so team for standing for the cause of the society in right approach. The chair requested the Anya so-and-so to cooperate with the government in bringing justice in this. Now, my lord, what had happened? Pursuant to this, on 19th, they have given the approval for preliminary inquiry that is mandated under Section 17 of the Act, PC Act. And thereafter, next day, my lord, on 20 itself, the approval was given for registration of the FIR. So FIR was registered, my lord. Now, Anti-Corruption Bureau has been given a go-ahead signal. Sir, you registered a FIR. Now, FIR was registered. Now, kindly see the predicaments that I am facing in this case is Annexure 7, page 37, my lord. Where is the judgment? No. Printed code. Now, my lord, kindly see this morning, yesterday morning, my lord. No, 7:35 a.m. is the last scene. My lord, yesterday night, there was a call to me. And in the morning, my lord, I received this WhatsApp message.
Which was WhatsApp message?
Page 37. The summon, in the form of summon.
Page
Annexure
27.
Yes. Wait.
It's not page 27, it should not be.
No, page 37. No, my lord. So then what had happened? I got a call, my lord.
No, what is this? He got a call. I mean, he got a call.
I got a call from this number.
Page 37.
Yes. Pradeep Mandal, my lord. So then, my lord, what had happened?
He got a call from Pradeep Mandal.
Pradeep Mandal.
A person called Pradeep Mandal.
Pradeep Mandal. And thereafter, my lord, what had happened? When I made a mention this morning before this honorable court, this particular message was sent to me to appear today in this court. This has not been annexed. Yeah, this is the where is that clear one? These message, summon message, was served to me through WhatsApp by this morning, Milord.
This is not a message, it's the full summon says.
Full summon through WhatsApp, Milord.
Through
And
WhatsApp, yeah.
that is not permissible under law.
They show me the law.
Yes, I have this.
But does it say WhatsApp message or does it say like service of notice by WhatsApp?
Service of notice.
It's a media.
I'm grateful, my lord, for correcting, my lord. My lord, the issue before me is in the first summon, my
So
lord.
here this notice was sent on 21st.
Yes, my lord.
Okay. Now it was dated 21st.
Dated 21st, I was verbally.
1 second. I mean, this was the same thing or like
same case.
Same case.
Different notice. On 20th, the first summon was served.
20. I mean, this 28th you have been asked to appear on 24th.
Yes, my lord.
You have been asked to appear on 24th. Correct. 24th 11 a.m.
Yes.
Now this has been sent and
Sent
saying
to
asking
appear
you
today.
To appear today itself.
Today.
Okay.
So, my lord, why this is not correct in terms of section 35 of the BNSS? My lord will kindly have this page 12 internal, the directions. In the Satyendra Kumar Anchal case only it is given, 2024, which I have given.
Satyendra Kumar until a page where paragraph?
Paragraph is not mentioned because I have directly printed out from Supreme Court website.
Okay, which
page 12, page 12, my lord.
12. Yes.
It says all the states
UTs must
UTs must issue a standing order to their respective police machinery to issue notices under section 41A of CRPC 1973, section 35 of BNSS 2023, only through the mode of service as prescribed under CRPC 1973/BNSS 2023. It is made amply clear that service of notice through WhatsApp or other electronic mode cannot be considered or recognized as an alternative or substitute to mode of service recognized and prescribed under the CRPC. Prima facie, my lord, this is not only the violation of the law laid down by the Honorable Apex Court, but the statute as well, my lord. Now, my lord, if I'm not...
Mr. Tara, tell me one thing.
My
I mean, see, Satyendra, I mean, this case, until this case say, it may be, it is made amply clear the service of notice through WhatsApp or other electronic modes cannot be considered or recognized as an alternative substitute. Now, this notice has been, I mean, scanned, correct? It has been scanned and like sent to you, only the mode is WhatsApp.
Or the mode of WhatsApp.
And it's not, I mean, it's not that like they have typed it out in the WhatsApp, made it summarized, something like that.
No, my lord,
It's properly there.
It's properly done, but the mode of affecting the service.
Make mode of affecting the service, service was this.
Yes,
WhatsApp.
WhatsApp. So, my lord, these two, this was much after thought. They have given a date backdated 21st because when I started preparing the collection of the documentations to bring before them, as per their directions, then suddenly I was asked to appear today, my lord. Now I'm nowhere. I'm nowhere, my lord. And my lord, I was planning to appear on 24.
Well, maybe the other councils would have been here, Mr. Tara.
No, my lord, I have made 10 frantic call.
I mean, there is nobody in the court. I mean, like for appearing for that.
No, nobody is there, my lord. My lord, kindly protect me till such time. Otherwise, I'm at jeopardy, my lord. And my lord,
no, this court can, the most court can do is like, I mean, you can be. I mean, you can go and appear on 24th. Yes. The way they have given earlier.
I'll appear, my lord. Until such time, I may kindly be protected, my lord. But this is anticipatory bail, my lord.
Heard Mr. T. Tara. T. Tara, the learned counsel appearing for the accused applicant. Also heard, no one is there. Tara, so and so.
My lord will record. I have made a 10 frantic call.
Okay, that I mean.
So that the court and everybody is safe, my lord.
So and so, this is an application under section 482 of BNSS 2023 praying for granting pre-arrest bail to the accused applicant in connection with ACB PS case number 13/2025 dated 12/12/2025, registered under section 61/336/316 in bracket 5/318/319 of VNS read with section 7 and 13(1) small a small b stroke 2 of PC Act 1988. It is the case of the petitioner, a case of the applicant, is that the state government of Arunachal Pradesh through the commissioner in bracket land management bracket complete Itanagar issued a preliminary notification for acquisition of land for the construction of LADA dash Surly Frontier Highway project package 4 and 5. You are on both the packages.
No, only 5.
Only 5 in East Kameng district, SEPA, in terms of provisions of right to fair compensation and transparency in land acquisition, Rehabilitation and Resettlement Act 2013. Pursuant thereto, the DC, SEPA, issued notices inviting claims and objections of the concerned landowner and interested persons. Full stop. Subsequent to the issuance of notices, there arose widespread grievances and objections amongst the landowners, beneficiaries, and other affected persons. Facing with that situation, in order to address and amicably resolve the issues, a committee was constituted by the land affected persons themselves. And the present applicant was unanimously selected as the chairman of the said committee. So it's a self-made committee, right? I mean, there is no, I mean, it is not, I mean, done by government or some authority.
It's by the affected people themselves.
Okay. In view of the aforesaid consensus and being the chairman of the committee, it is stated that that the present applicant was facilitating the issues relating to land acquisition as well as compensation to the
beneficiaries of the
to the beneficiaries of such land acquisition and land acquisition. Full stop. Full stop. The present it is also also stated that the present applicant is also one of the beneficiaries beneficiaries in the list of beneficiaries that has been taken out by the government, by the authority, by the authority. Full stop. Full stop. However, it is however, a written complaint dated 4/11/2025 was filed by one Sri Ramesh Taku, the president of
All Nisi Youth Association.
All Nisi Students
Youth Association.
All Nisi Youth Association in bracket ANYA, East Coming District Unit SEPA before the officer in charge, Anti-Corruption Bureau, Itanagar, alleging misappropriation of public funds in connection with aforesaid Lara Surly Frontier Highway Project Package 4 and Package 5 in East Coming District, Arunachal Pradesh. It is stated that in the FIR is not there with it. It is stated that in the FIR, allegations have been made against one Mr. Himanshu Nigam, the IS, the Deputy Commissioner, Sri Takam Ketchup, the District Land and Revenue Settlement Officer, Sri CK Tayum and some other officials and some other officials. Full stop. It is stated that, however, however, that the present applicant is not named in the FIR, Full stop. Next paragraph, right? The learned counsel appearing for the accused applicant submits that in spite of his several attempts, he could not contact and serve a copy of this of the present application to the learned counsel, learned special counsel, right? Learned special counsel,
Special Public Prosecutor.
learned special public prosecutor, prosecutor for
Anti-Corruption. Arunachal.
Anti-Corruption Arunachal Pradesh. Arunachal Pradesh. He further submits that in spite of his desperate attempt, he could not procure a copy of the FIR also. Full stop. He submits that though a summons was issued to him dated 20/12/2025, which was in fact delivered to his residence wherein he has been asked to appear before the concerned authority, before the investigating officer, ACB, PS Civil Secretariat Itanagar at 11 p.m. on 24th December 2025. And he had been asked to come prepared with various documents relating to the issue for recording his statements. Correct. Recording his statements. Full stop. However, yesterday night it is submitted by the learned counsel that yesterday night he received one WhatsApp message wherein where is that page?
Single page, Milord. First phone call, Milord. Phone call from
Okay,
NHS 7.
first call.
Yes. NHS 7, Milord.
He received, but how do you know that this person, con call on what? I mean, when this Mandal was speaking, what? He's an officer or what?
Mandal phone was used, Milord, the SIC used by the police.
Then Pradeep Mandal is who?
I think he's a constable in the Anti-Corruption Bureau.
Okay. Yesterday, that is on 21st, right?
Correct.
That is on 21st, about 7:35 p.m. about 7 to 7:30 p.m. AM. Sorry.
AM.
So it can't be night.
It can be
So
like
yesterday morning you got it.
yesterday morning.
So yesterday morning you read. Yesterday morning at about 7 to 7:30 a.m. he received a call from one Pradeep Mondal, who identified himself as one of the investigating officers. What did he say?
Investigating officer used his phone. Probably this Mandal is a constable in the.
But no, what was the I mean what was the talk there?
They have to appear before him today.
Okay.
Without
identifying himself, you're right, without identifying himself, intimated the present applicant that he should be, and he must appear before the investigating officer on 22nd. On 22nd December, that is today. Full stop. Full stop. He further submits that
that single page.
he further submits that though he was at a loss what is to be done, as he has already been summoned to appear on 24th of December. Full stop. However, at about what time you received that WhatsApp message?
10.
At about 10 p.m. on
10 a.m. morning today.
10 a.m. morning today.
Today.
10 a.m. At 10 a.m. Morning today, that is on 22nd December, he received a WhatsApp message. Where is that? Page?
Well, I have given single page.
Oh, sorry.
Negative. Well, I have it.
1 second. It should be here. It should be. Yes. He received a WhatsApp message wherein a scanned copy of a notice dated 21/12/2025 was sent to him. Full stop. Sent to him. Don't write full stop. Sent to him, which mentioned that the applicant, which mentioned that the present applicant is required to appear before the investigating officer on December 22, 2025 at 11 a.m. 11 a.m. Full stop. He was further asked to come with all valid documents, for example, valid documents like ID card, Aadhaar card, etc., as well as relevant documents relating to Lada Sadli Frontier Highway project in brackets package 4 and 5, West Kameng District, SEPA. Full stop. The learned counsel appearing for the accused applicant submits that, in fact, he submits that though he has been preparing to appear on 24th of December as per the earlier notice dated.
Page 35.
Page 35. Earlier notice dated 20/12/2025 on 24th December, he was surprised to receive the instant notice, which requested him to appear on December 22nd, 2025. Full stop. He submits that since he has received the WhatsApp message only at 10 p.m., it was quite impossible, or it was quite difficult, rather impossible for him to appear with all documents before the investigating officer at 11 a.m. Full stop. He submits that he is apprehending arrest in the instant case as could be made out from receipt of the aforesaid notices. Therefore, he has approached this court for some interim relief in the instant matter, so that he can get sufficient time to appear before the investigating officer as per the notice investigating officer on 24/12/2025 as per the earlier notice dated 20/12/2025. Full stop. This court has gone through the materials which have been brought before this court, as well as heard the submissions made by the learned counsel appearing for the applicant. Full stop. It could be seen that by earlier notice dated 20/12/2025, the applicant was in fact called to requested to appear on 24th December 2025. However, it could not be understood why he has been suddenly sent a WhatsApp message and asked to appear, or a WhatsApp message which was delivered to him at 10 a.m. and he has been asked to appear immediately at 11 a.m. before the investigating officer. Full stop. The learned this court has also considered the judicial pronouncement of the apex court in the case of Gurbaksh Singh Sibia. Apex court. In the case of Satinder Kumar Antil versus CBI and another, in bracket you write miscellaneous application number 2034/22 in MA 1849/2021 in SLP in bracket criminal number 5191/2021, decided by the Honorable Apex Court on but this was an interim order.
Yes, ma'am. Yeah. On 18/3/2025. On the name. List here.
I think the final order has been passed in this case. That order has already come.
Already come.
This is an interim order. How can I refer to this?
But then still the direction is there. This is directions. Directions can always be.
No, directions are there, but like this, this Satinder Kumar Antil case has come out already.
Yes, has already come out.
He should have brought it.
It was in absolute hurry, my lord. I was in 2 hours drafting this bail application, and
see, this court has also could not go through the Satinder Kumar Antil's case. I have seen it, but like I could not go through properly.
I understand.
So I do not know.
But in next date, I will provide it.
What was the line I have written? No. Read it from the beginning. This court has also considered. One second. Also considered the order passed in so and so case, so and so dated there is no date also.
There is no
dated 21/1/2025. 21/2025.
Yeah.
No, we'll not refer to this case, okay? Because this will be difficult
for a moment. I'll furnish the
we will not refer. Otherwise, also, this court is of the view that you should be given some protection. So we will not refer to this. This is not required.
Fine, my lord.
This line you cut it out, no? Consider. So what was the last paragraph, last line? Oh, so and so, so and so. Okay. Taking into the whole aspect of the matter, and since the learned counsel appearing for the accused applicant submits that he is very much ready to appear before the investigating officer on 24th as requested by by the earlier notice dated 2012-2025. 25 this code 25 is of the opinion that the applicant should be given some interim relief, given the required interim relief, so that the applicant can cooperate with the investigation and appear before the IO as requested to be appeared at 11 a.m. on 24th December 2025. Full stop. In view of the aforesaid, it is directed that in the event of the applicant's arrest by the investigating officer in connection with ACB PS case number 13/2025 25, he shall be released on interim pre-arrest bail on furnishing of a bail bond of rupees 50,000 with a surety of like nature to the satisfaction of the arresting authority, subject to the following conditions. Number one, that the applicant shall appear before the investigating officer at 11 a.m. on 24th December without any fail. Full stop. That the accused applicant shall fully cooperate with the investigation and submit the documents as well as submit the documents as has been sought for by the IO. Then you write the accused applicant. Then you write the applicant shall not try to hamper or tamper with the investigation. Then you write list the case. List the case on
7th January. I will be out of country.
List the case on 7th of January.
Fine.
7th of January. In the 7th of January. That's all.
Grateful.
That's
Item number 6.
Lordship, before that, Lordship, item number 25, Lordship.
Yes.
Your
Lordship, we would like to take a short adjournment in that matter. The main counsel is in the other court on his legs, so we would humbly pray for a short adjournment.
But you should have mentioned it in the morning.
I'm so sorry, Your Lordship. We did not know that.
You write item number 25. You write. You are your name.
R. Takam.
You are appearing for home petitioner.
Dicky Pangin.
I mean, it is a criminal appeal.
Yes, Lordship, I have spoken to him. He was praying to post it after vacation, Lordship.
After 2 weeks.
So and so appearing for Mr. So and so, the learned counsel appearing for the appellant submits that the leading counsel in the instant case has some difficulties today, which has already been intimated to the learned APP for the state, let the matter be listed. Let the matter be listed on.
Lordship, after vacation, Lordship.
Yes, after vacation on 9th.
Lordship.
On 9th of January.
Yes. Much obliged.
Oh, I do call it. You write call for the CD also in this other matter. That last matter. Call for the CD.
May I please, Your Lordship?
A huge, I mean.
No. Lordship, don't have to take the file. No, Lordship, keep it. Lordship, for the time being, keep it. Lordship, on the.
Who is appearing for the other side?
I'm appearing for the respondent.
He is appearing for two of the respondent lordship. Mr. Majumdar has appeared for two of the respondent lordships. 4 and 5. 3 and 4.
So is it a matter which can be done by VC, Mr. Majumdar?
No, he is expert lordship in VC lordship.
No. I'm not expert, man.
Nowadays, he is very techno-savvy lordship, so he is expert lordship. We are not.
Man, I have got some personal difficulty.
He
That is why I
is
couldn't
techno-savvy,
go.
yeah,
man.
that's correct.
So
Today-
this matter lordship arising out of, it's an election process of a students' union. Lordship, there is a all Nishi Students' Union,
Yes.
like the All Assam Students' Union of Assam, Lordship.
Mhm.
There is All Nishi Students' Union here in Arunachal Pradesh, Lordship.
Correct.
The All Nishi Students' Union is the parent body. And they have their branch Students' Union, Lordship, like our district Students' Union, that the Mahakuma Puri Students' Union, like that. So the branch Students' Union, they are the feeder. They send the feeder for the state Students' Union. So before the state Students' Union election took place, all the branch Students' Union, they have their election. They send their representative to the state Students' Union, delegate.
So the voting can be done by the delegates only.
Yes, Lordship. Voting, Lordship, that's the point. That's the crux, Lordship. The Lordship has come directly to the point. That's the crux. And who will vote? The delegate will vote. That's the crux. So what happened, Lordship? In this case, Lordship don't have to touch the, that Lordship has taken a small note. I'll give the all pages and the Lordship. Initially, there is a title suit number 1 of 2024.
Yes.
The Lordship, that pagination is 219 to 232 in the paper book. In the paper book, now, Lordship, there is a paper book, Lordship. After the last court order, there is a paper book, Lordship. These two volumes.
Yes.
Only this volume, Lordship, you have to see. In the paper book, Lordship.
Yes.
And this title suit number 1 of 2024, there is a Mizze case 4 of 2024.
Mizze for what?
Mizze under Order 39, Rule 1 and 2.
Okay.
And the order is of 25/10/2024.
25/10/2024.
Yes.
Yes.
By the civil judge.
Yes.
Against that, there is a civil appeal. Number one of
I mean, what was the
against the injunction restraining that the who will vote and what else. Lordship, I'll read that part.
Okay, please give me this.
Lordship, then against that, there is a civil appeal, 1 of 2024. And in the civil appeal, it is the page 354 to 365.
Civil appeal number?
Civil appeal number 1 of 2024.
24 only?
Yes, 1 of 2024. Yes, 24.
Okay, 24. Okay, page number?
Page 354.
354.
To 365.
Okay.
So this petitioner number 2 and 3 here in this revision petition were declared as the president and secretary, Lordship.
In the election happened.
In that year, Lordship, and the court has given that.
I mean, in 2000, no, this. I
For
mean,
the branch students union.
This election happens every year or what?
3 years.
Every 3 years. So every 3 year election happens, and in the year 2024, they have been elected.
Yes.
Petitioner number 2 and 3, they have been elected as president and
secretary for the branch students union.
President and secretary for the branch.
Branch students union.
Okay, I mean, how is it structured? I mean, how many branches are there?
It is all two.
I mean, it is a state union, right?
Yes.
So how many branches are there?
There are lot many branches. Only one branch has
there.
problem.
So branches have their own elections.
Yes.
And one of those branch elections, what is that place called?
Apsiksu.
Apsiksu. So for, okay, this place called Apsisku, branch selection happened in 2024.
Lordship, the all Paling, Sangbang.
No, these are all branches.
No, it is the name. Lordship, it is all Paling, Sangbang, Yangte, Gangte, and Tarak Langdi Students Union. These are the areas, Lordship.
Okay, for these areas, I mean, covering all these areas, there is a branch. So in the branch, I mean, election happened and these two people got selected.
Yes.
Elected, sorry, elected.
Yes, Lord.
They had the petitioners number 2 and 3.
Yes.
So they became kind of a delegate from that particular branch.
Yes.
Correct?
Not the delegate, there are many other delegates also.
Correct.
They are the president and secretary elected for the branch students union.
From that branch, president and secretary. Okay,
Yes.
correct.
Yes. Then against that, Lordship, in the civil appeal, the civil appeal.
Election is for that particular.
Yes.
Okay.
This is very important, Lordship, to take note.
Okay, for that branch election happened and that has been, that is under challenge.
That is under challenge. They not in this case, there.
Okay, initially that was challenge.
That was under challenge.
That was under challenge in which title suit? That
Title suit 1 of 2024.
1 of 24.
Yes.
Okay.
Yes. That I read the. So the by 1/11/2024.
So 1 of 2024, that, I mean, those, I mean, that was challenged by the respondents, maybe, whoever.
No.
Then
Somebody has set us, their election was set aside by the Anshu's leader. So that is challenge.
This title suit was filed by whom? 2024.
2 and 3.
2 and 3 was.
Petitioner number 2 and 3
was elected. They were elected.
Their name has been here by the Anshu, the main body, the leader of the main body.
Anshu is the state organization.
Yes, state organization. Yes, that was challenged.
Okay, that state president or whoever, who were there in the helms of affairs, they said this election is not correct.
Yes, yes, that was challenged.
So election is not correct. So their selection was election was. I mean, they said it is not correct.
Yes.
So against that, I mean, you all came to that filing title suit.
And court has given an injunction. Then against that appeal. So on 1/11/24. The civil appeal filed by the other fraction. The
injunction was given.
Yes.
So you have been asked to operate.
Yes.
Correct.
Yes.
And we have been asked to operate, both of you.
Yes.
Then the other side has come for an appeal. Against that temporary injunction.
Yes.
Against that temporary injunction,
Yes.
appeal has been filed.
Yes.
So appeal was decided.
Yes, decided on 1/11/24.
Appeals was decided on
1/11/24. The appeal was dismissed.
Appeal was dismissed.
And this attains finality. Lordship can keep here. Lordship, it attains finality.
So appeal was dismissed.
And it attains finality. No one has challenged that. It attains finality.
So no, there was no challenge to that.
Nothing.
So 1/11/2024 was passed in civil appeal number 2024.
Yes.
And which
civil appeal
1 of 2024, and wherein this okay, understood. Then
Lordship, then what happened, Lordship? They were trying to the next suit. There is a next suit, Lordship. There is a Anshu election is declared in the meantime.
So Anshu is the state body. So election was
declared.
Date was declared. Election date was declared.
Yes.
Okay.
So the dates were declared, and then this person, the who were given the secretary, president, and the delegates, they were not been allowed.
So since there was an injunction and like they have been allowed to work.
Yes.
Or like operate.
Yes.
And other side's appeal was since dismissed.
Yes.
So they are rightly elected persons.
Yes.
Correct.
So now the petitioner 2 and 3 has sent the delegate to the Anshu election.
Okay. How many delegates you need to send?
51.
51 from what? 51 from one branch.
All that, Lordship, that I have read, Lordship. that
So one branch,
all Palin.
51% delegates you need to send for voting in the
Unfree election.
state elections.
Yes.
Correct. Then
And here the respondent number 2.
so these 51 delegates were not allowed to participate in the state
Yes,
election
yes.
because probably stating that these two people are wrongly elected. I mean, they
Yes,
the
yes, that's,
original
Lordship
people.
is very correct, Lordship.
that was
Without
the thing?
looking at the document, Lordship, that is what the Lordship's
probably
that is,
that is it.
yes, that
Okay,
is the
okay.
correct position. Yes. But what happened, Lordship, those person who was not elected, whose name was rejected, whose appeal was already decided, that dismissed, their person was allowed to vote. All of them. 54. They have sent 54 delegates. Reta half action. They have sent 54.
Their branch.
Who lost the appeal? Which has attained finality? They have sent the 54.
And those people were there in that I'm from your branch only. Correct?
This is
From your
from my branch only.
Pretending to be upsix.
Now they are pretending that no, we are we can send the delegate. But they lost the everything.
They lost the election that time.
Yes.
Election lost in the court also. They were disqualified even, Lordship. So, Lordship, challenging the second part, the second suit was filed, that is title suit number 17 of 2024.
Challenging what exactly?
The challenging that our faction was not allowed to vote. 51 delegate from our faction.
So they filed a suit.
Yes.
Challenging.
Title suit 17 of 2024. Filed on 13/11/2024. It is.
So it was challenging this thing. So this 51 people filed this suit.
Not all 51, Lordship.
But amongst them only.
Amongst them.
One other, it's bearers of absence.
Petitioner number 2 and 3 and 21 others, Lordship.
And 21 others. They basically challenge their,
that they have not been allowed
to participate in the election.
Yes. So that is page number 233 to 240 of the paper book, Lordship. Now this paper book.
Page number?
Page number 233.
233 to
240.
240.
Yes.
Okay. So this was this.
It is this page number 233 to 240 is the order.
Filed before. Filed
before the civil judge, junior division.
Okay.
Papumpare.
So what happened there?
Yes, on 14/11/24.
14/11.
Yes.
It was filed on 3/11.
Yeah. 13/11.
13/11. Sorry.
13/11.
And 14/11 it was heard.
Yes. Mistake is 18 of 24.
Was heard. So you, there was no interim given to you.
Yes, it is the page 233 to 240.
230 to
233.
240. So their order was passed. In the Mizze case, right?
Lordship, you have to read, Lordship, because this is the.
Correct. I'll read it. But like on 14/11/2024 in the Mizze case, there was an order passed whereby your prayer was not allowed.
No, allowed.
Prayer was allowed.
Yes. Okay. Allowed means, Lordship, my all prayer was allowed. Lordship.
Prayer was allowed.
Yes.
Okay. But if the prayer is allowed now, why you were before this court?
That's what, Lordship. That's the shocking, Lordship. Lordship will not believe what happened in this. It's a jungle law, Lordship. It's a jungle law going on.
Okay, so this is prayer was allowed by 14/11. So that is there at 235.
The Lordship, please come to page 233 in the first volume, Lordship.
233, yes.
In the first volume, page 233.
Yes.
Lordship, get it, page 233.
Yes.
It is the order dated 14/11/24, Lordship. Get
Correct. I got it.
Lordship may straight come to page 235.
Yes.
Now, heard learned counsel. Peruse the application, also peruse the main petition entitled suit number 17 of 24. It is true for the granting injunction under order 39 of the petitioner has satisfied the court that their plea satisfied the ingredients, namely prima facie case, balance of convenience and irreparable loss and in their favor. Now, in this case, in hand, it appears to be the dispute regarding the eligibility of the petitioner plaintiff to participate in the upcoming ANSU election. And from the perusal of the notification dated 9/11/24 and 12/11/24, it transpired that the prima facie case is made out in favor of the petitioner plaintiff. Further, it is true to be year of the civil right to result in irreparable loss and such matter at hand. Furthermore, it appears that there exists no alternative remedy to the harm that the petitioner plaintiff faces if they are not allowed to participate in the ongoing ANSU election. Thus, it appears that the plaintiff petitioner has succeeded in establishing the ingredient of irreparable loss in their favor. Furthermore, the petitioner has also succeeded in the showing that the balance of convenience lies in their favor. The petitioner submits that the respondent defendant faces no harm or risk if the injunction is granted in favor of the petitioner. In fact, from the fact of the case as presented by them, it appears from the petitioner's plaintiff stand facing a huge risk of violation of their civil right. As such, upon being satisfied with the submission made by the petitioner plaintiff, I am inclined to allow the prayer of the petitioner plaintiff and direct that the operation of the notification dated 9/11/24 and notification dated 12/11/24 are suspended till further order. Further, defendant and the particularly defendant number 1 to 8 are also directed to enroll the name of the plaintiff and the delegates recommended by the plaintiff number 1 and 2 in the list of the delegate of ANSU election 2024, and that they be allowed to participate and contest the vote in the election. Furthermore, the plaintiff number 21 to 24 be allowed to file their nomination and contest the ANSU election.
When was the election? I mean, this state election, ANSU election?
On 16th of November. It is from 16 to 19, 3 days, Lordship.
So that what happened to that?
That is what I'll come one by one, Lordship. They flouted the court's order, Lordship. They've done the deputy commissioner and SP been thrown out from their office, Lordship. SDPO has given a detailed report, Lordship, that this person should be arrested immediately. All of them have been thrown out. The civil court has passed an order in an execution petition, Lordship, that my order be, the civil court has directed the deputy commissioner has directed the SP has sent the whole police force. They have thrown out all of them. And the people were hospitalized, Lordship. And already the search sheet is there, most of them was arrested, Lordship. So, Lordship, then there is another direction,
So
Lordship.
they allowed to participate in contest. Yes, after
Yes.
that?
Then, furthermore, the plaintiff number 21 to 2 allowed to file their nomination and contest the ANSU. And now, Lordship, this is very serious. Dependent 9 to 12 and the dependent 13 to 63 be prohibited to participate in ANSU election of 2024 as a member of APSITSU. Why, Lordship? Because that, Lordship, there in the court order, it was already decided who will send the delegates, who will send, who will not. They are the delegates sent by this rival factor, Lordship, who has lost the election, who has lost all the cases before the court,
Correct.
which was attained finality. Lordship, this order has not been complied.
So this order was passed on
14/11.
14/11, and the election they
on 16/11.
So they hold the election on 19/11.
No, 16 to 19.
16 to 19.
Voting ended on 25th.
Voting, yes, but they started on 16th. So the process.
Okay, this was the order. Then what happened?
Now I filed an execution, Lordship, under Order 21, Rule 32. Read with 151. That, Lordship, will get at page 255, 256.
of 20.
It is miss case number 19 of 2024.
Connected to title 17 of 20.
It is from the title suit 17 of 2024.
For
Lordship-
execution.
Yes,
Is that-
255, 256 in the first volume itself, Lordship. 258, Lordship, it is 4 pages, Lordship.
It starts from 255.
Yes, 255. It is 21/11/24, Lordship, execution.
Yes. So this is the order. Where is
Lordship,
the?
this is order dated 21/11/24.
Uh-huh.
The next page, Lordship, may please come. Hard and Perus, Lordship, get it at page 256.
Yes.
Page 256.
Yes.
Hard and Perus, then he has written all this.
Mm.
Then it is seen that this court by order dated 20/11/24 in Mizze case number 20 of 24 and Miss case number 13 of 24 in title suit 13 of 24 directed Deputy Commissioner come District Magistrate Capital and SO Capital to enforce the order dated 11/11/24 in the aforementioned case. As such, considering the similarity of the situation, I am inclined to direct the Deputy Commissioner, District Magistrate Capital and SP Capital to provide assistance to the petitioner in the present case in ensuring the compliance of the order dated 14/11/24 in Miss case number 18 of 24 in title suit number 17 of 2024.
Yes.
So accordingly, this was flouted, Lordship. Now, the Deputy Commissioner on 25/11/24 went there and it is page 257, Lordship. Yes.
67.
260? 267, I'm sorry, Lordship. It is 267, Lordship.
To the purpose.
When he failed to, Lordship, comply with the execution order, Lordship, now the Deputy Commissioner at page 267,
Yes.
To the purpose.
he withdrew the permission to hold the election, Lordship.
Okay. It was passed on 25th of November.
Yes, because 26th is the election. 25th, yes.
627.
No, no.
627.
No, that was it. Now, Lordship, may please come to page 274. 274, second volume.
Second.
In the second volume, Lordship. First page. It is the notification by respondent number 2, Lordship. It is hereby.
Respondent number 2 is the chief election
Yes, yes.
commissioner for that particular
Yes,
body.
yes, Lordship.
Mhm.
It is hereby notified that the students of various colleges and university and NLA. It is also informed that all total so-and-so vote cast has been recorded officially, which has been done in utmost transparency and while maintaining the free and fair for the smooth conduct of the election process. Thereafter, the counting process shall be started, which shall be notified soon.
Yes.
This is issued for kind information and necessary action on 25/11.
So election happened and this was notified.
Yes. Election completed, Lordship. In the first paragraph itself,
Yes, yes.
that at 9:15 of 25th of November 2024. In the first paragraph is several page. Now, Lordship, please come to page.
Yes. So this was done then.
Then Lordship may come to page 284.
Mm. 284, yes.
Deputy Commissioner has directed the Superintendent of Police to seize all the documents they need from the Chief Election Commission. Lordship get it in the top, the whole title suit number, means the case number, it is there. Then in the last paragraph, now therefore, in view of the above, the Superintendent of Police, Capital Itanagar be thereby directed to take the custody of the election material in connection with the Anshu election of 2024-2027 from Siddharth Hall, Itanagar with immediate effect till the final outcome from the Honorable Civil Judge number so-and-so, Itanagar benches UPR. Lordship get it. So this is the Deputy Commissioner has directed the Superintendent of Police. Now Lordship may come to please next page, 285. But yes, it is this type copy. 286. My lord, no one will believe that what can happen. All these type copy are there. 284, Lordship, 285 is the type copy, Lordship can read very well. Now, Lordship, may please come to page 286.
Now, 286 type copy is 288.
Yes. Challenger of the execution order regarding the seizure of election material for the Anshu election reference. With respect, I write to spare your kind office the challenge of the enumerator during the execution of your effort regarding the seizure of the election material from the custody of the election commission Anshu on so-and-so at Siddharth Hall. The undersigned, acting under the direction of the Superintendent of Police, capital wide number so-and-so, face the following difficulties. Non-compliance of the so-and-so. I, Sri so-and-so, returning officer of the Immense General Conference, representing the Election Commission, refused to hand over the election material, citing that the presence of Chief Election Commissioner, Mr. So-and-so, was essential for the process as is directed for transferring the election item. Delay by the Chief Election Commissioner. Upon contacting so-and-so, he expressed his inability to act immediately and requested a time extension of 3 to 4 days. He was advised to formally seek such extension from your office, but no such request has been received on date. Sensitive and controversial nature of materials. Despite repeated requests, Sri so-and-so declined to release the material, citing the sensitive nature of the matter and in lack of independent authorization. He is the client of this respondent number 3 and 4. He is 3 and 4, respondent number 3 and 4, my lord. He is the person, Lordship, respondent number 3 and 4. And the deceased respondent number 2. Yes, Urum Tamin is the respondent number 2.
He is the Chief Election Commissioner.
Yes, he is respondent number 2.
So he said, the returning officer said that Chief Election Commissioner should be there. In absence of his, I can't give you.
Yes.
So, but this person, when contacted, he said that he can't come immediately. Okay.
Yes.
Both
Now-
of them are from the same organization.
Now 3. Sensitive and controversial nature of material. Despite
that
Yes, I have
got
read,
them.
Lordship. Now, Lordship, may please come to page 292.
Yes.
Now there is an observer for this election. 2 observers, not 1.
Okay.
A neutral observer Lordship, it was appointed by civil and they both of them were neutral observer.
They signed the polling register.
This neutral observer has signed the polling register and everything. They have given this report. What happened in this election, Lordship? Now, Lordship may in page 292 come to paragraph 3.
Yes.
Thirdly, we would like to highlight the violation of the judicial authority. The Honorable Court, though its order dated 14/11 and 21/11, had explicitly directed the Civil Election Commissioner to allow the delegate of Bikitania and so, and they are the petitioner 2 and 3, Lordship, to commission to allow the so and the of all Paling, Chanming, Yangte, Gangte, Tarak, Lendi Students Union to participate in the election and exercise their voting right. However, contrary to this directive, these delegates submitted by Mr. Rai Taha team were allowed to vote. This blatant violation of the court order undermines the legitimacy of the election process and constitute a serious breach of judicial authority. The Deputy Commissioner ICA White so-and-so, dated so-and-so, and the Superintendent of Police ICA through letter dated so-and-so, directed the Civil Election Commissioner to comply with the court order. However, the Election Committee ignored this directive, showing disregard of the law. Consequently, the Deputy Commissioner issued order dated 25/11/24, withdraw the permission of the Ansu general election due to the non-compliance with the Honorable Court order. Now, Lordship, in the next page, page 293, I'll skip the para 4, Lordship. Let us come to para 5. Vice so-and-so, dated 29 November 2024, the Deputy Commissioner DCICR have ordered to hold up the oath-taking ceremony until the final verdict are issued by the following pending cases: Mizze case number 19 of 24, Mizze case number 18 of 24, and title suit number 19 of 24, currently under consideration by the Civil Judge, Junior Division, and the Honorable High Court, Itanagar, Guwahati Permanent Bench, UTP. However, the Election Commission team had failed to comply with the deceased order and illegally conducted the oath-taking ceremony on 30th November 2024, which clearly demonstrate misconduct on this part. Their action are neither in compliance with the deceased directive nor with the court's order. This highlights bias, unfairness in the election process. Such action by the Election Commission team are unprecedented in the history of Ansu election and clearly indicate a lack of impartiality and transparency, casting doubt on the fairness and the integrity of the entire election process. Now after all this, Lordship, after all these things happen, all this report, now we file the present suit. The title suit 21 of 2024. On 6th of December, 6/12/2024, because Lordship,
What happened to the other title suit? I mean, okay, that order was okay.
yes, that order is already, one is already attained finality. The second is already directions are there. All these things, even the, now on 6/12/2024, we have filed the third suit, title suit 21 of 2024, the present suit, Lordship.
Case number.
So you filed this title suit?
Title suit 21 of 2024, and an application under Order 13 and Rule 1 and 2, which was registered at Mizze case number 25/2024.
Correct.
Lordship, this title suit 21 of 2024, Lordship will get in the paper book, page 38 to 77. How?
Page 238.
No, only 38, Lordship, page 38. In the new paper.
It's a new paper. Okay. Okay. Now the volume 1, 34?
38 38 to 77.
77, correct.
And Mizze case is 25-24 is page 99 to 111.
99 to 111.
Now, there is an injunction order, Lordship, passed on 28/1/2025.
21,
28.
28, 1, 2025.
Yes, 2025.
In Mizze case.
After hearing all the parties, Lordship. It's an inter-party order, Lordship.
So injunction was given.
Injunction was given. That is page 193 to 196. What did you do?
193 to 196.
Yes.
That was the order.
Yes.
Then
One of the finest order I've seen, Lordship, from the trial court. Nowadays, we cannot say lower court even. There's a trial court, from a trial court. It's a beautifully written injunction order, Lordship. Lordship, it started at page 193. Order dated 28/1/2025.
okay, where is that operative?
Operative, Lordship, may please come to page 194. Bottom. Lordship, get it.
One second.
Page 194, last line.
194.
194, last line.
Okay.
I have also perused. Last line, Lordship.
Yes.
Page 194. I have also perused the application and all other materials placed along with it, and I have also perused the judgment relied upon by the applicant. From the perusal of the above, it is evident that there is a specific direction to the respondent number 1 to 9, filed order dated 14/11/24, regarding the applicants therein to be allowed to contest the election and the other party be barred from participating.
Yes.
The report of the official election observer. Now, Lordship, the Lordship will take note of this. The report of the official election observer and the order of the deputy commissioner and the superintendent of police makes it evident that the order dated 14/11/24 was not complied in toto by the respondent number 1 to 9. The said violation was even after the several intervention by the said authorities. So from the above, it is crystal clear now that the prima facie case is established in favor of the applicant. And Lordship will see, Lordship here, he has discussed everything and then he has written this. So from the above, it is crystal clear now that the prima facie case is established in favor of the applicant.
Right.
Now, and as submitted by the counsel for the appellant, that the contravention of the court order, the result in irreparable loss by the applicant, as the same cannot be compensated in monetary terms. It is seen that the applicant stands at losing his right, which otherwise would have been accrued to him had the election were conducted in fair and proper manner, and the allowing the other party to enjoy the fruit of the illegal act by prejudicing the right of the applicant would be travesty of justice. This right cannot be compensated by vesting upon the applicant by declaring the matter in his favor upon final adjudication of the suit at much later stage. Nor can the applicant be compensated. So evident that the applicant had made an irreparable loss in his favor. This court has carefully considered the harm that it could on behalf of the either party if the injunction is granted in favor of the either party. The court is also not oblivious to harm the respondent faces if the injunction is granted in favor of the appellant. At the same time, it is now also aware that the respondent has placed themselves in the way of the harm by their own doing, that is violation of the court's order dated 14/11/2024. By an act of their own doing, they have also prejudiced the right of the applicant. as rightly opined by the counsel for the appellant, the respondent ought to have complied with the aforesaid order unless intervened by the appellate court. Non-intervention of the court in the matter would only legitimate the illegal act of the respondent, by which the respondent number 10 has come to find himself in the position to being with it appears that the applicant faced more harm if the injunction is not granted in favor of the respondent does. As such, in my considered opinion, the applicant have succeeded in making the balance of convenience in his favor. Resultantly, the prayer of injunction of the applicant is allowed. The operation of resolve notification dated 29/12 with respect to the respondent number 10, Leon Gezi, is suspended. Legend Gyadi is suspended.
Who is respondent number 10?
He,
President post.
he is the president now.
He is here?
Yes.
He is respondent number 1.
He is respondent number 1.
So, I mean, operation of result notification dated so and so. With respect to respondent number 2 only suspended.
Yes.
Because we are only contesting.
Because my client has challenged that only. The all other posts he has not challenged, Lordship.
Okay.
Because being a president, he has challenged the president post.
Okay.
So that is why this order, Lordship.
Okay.
He's only a presidential candidate.
It's a president.
Other issues were not there.
No.
Only this.
My client has challenged the presidential election.
Mm.
And the president is there.
Okay.
And Lordship, in this case, Lordship can take note somewhere, Lordship. From the suit, there is a plaintiff, there is a defendant. The rest of them are the pro forma.
Okay.
Lordship will take note of that. I'll show that. Now, Lordship, against this order, now, Lordship, let me finish, Lordship. Respondent number 10, Legend Gedi, is also barred from representing himself as president of All Nations Students Union from 2024 to 2027. It is also barred. He is also barred from using any sign, seal, emblem, or any other symbol of the office of the union. He shall also refrain from exercising the power and function of the president of ANSHU. He shall also refrain from exercising the power and function of the president of ANSHU.
Yes.
The instant order shall remain in force till the pendency of the main title suit. The instant means the case application numbers then dispose of with this order.
Correct.
This is an interpretive order, Lordship. After hearing all the parties, after notice.
Yes.
Respondent 1 filed the civil appeal.
Now, Lordship, the present respondent number 1, only Lordship will take note of that.
So against that, the civil revision is filed or what?
Yes. No, Lordship.
Civil appeal filed.
Civil appeal file, Lordship.
Civil appeal file.
Yes.
For district court.
Before the district court. Lordship, what Lordship will take note here, he was the defendant number 10. So this injunction, nobody has come to the appellate court. Nobody has challenged this order except him.
Except respondent 1.
Except respondent number 1 in the present case.
78.
Lordship, may please come to page 78. Lordship have to take note of that, Lordship. Page 78. Because now so many persons will want to say so many words, but nobody has filed appeal. No one has filed appeal against that order.
So 28/1/2025.
Yes.
I mean, that was challenged by filing a civil appeal.
Appeal number 2 of 2025.
2 of 2025.
It is the page 78 of the volume.
78. So
78.
this was challenged only by the this
present respondent number 1, the defendant number 10.
Okay.
Legend
correct.
Gyadi.
Correct. He is the elected president.
Yes. It is the page 78. He is the elected president, Lordship. Lordship is very correct. That's the beauty, Lordship, to argue some cases before. The page 78, Lordship. Lordship, please see. Who is the appellant? The Legend Gyadi. There is no one else. Lordship, the next page.
Yes.
Who are the contesting respondents? Osuk Doka, Vicky Tania, and Gokia Tame. All others who are pro forma. There are no prayer against all others. The all others made pro forma. And all others party, all these parties has not filed appeal against that order. Now they will shout, now they will take time in the name of Legend Gyadi that today my senior is not there, tomorrow his senior is not there. All these party will take time in the name. But
We have not taken any time.
why he has taken it? I have not taken his name. I have not. Why? There's so many parties. Why he has taken his name? No. I have not taken your name. Why? Why Garat kun call Kwanai type Kotha Lordship? Lordship, may please come. Now, Lordship, here see. Lordship, please see this appeal. The appellant is Legend Gyadi.
Yes.
And respondent is Osok Doka, Biki Tania, and Gokia Tami. Now, this 6 and 7, Lordship, see.
6 and 7, yes.
Yes. They are pro forma, Lordship, in the appeal.
Mhm.
Who are they?
One
They
is
are the presiding officer.
one is presiding officer, other
One is polling officer.
polling officer. Yes.
Now Lordship will take note of this.
Respondent number.
And who are they? They are the subordinate of respondent number 2. They have to give report to respondent number 2, the Chief Election Commissioner. Because before the police also they said we cannot do anything. It is the Chief Election Commissioner have to come to give the document. We are nobody. We are nobody. We cannot do anything without the permission of the Chief Election Commissioner. Now they are everybody, Lordship. Now, Lordship, may please come to
Page 170.
178.
Page 7.
178 in the paper book, Lordship.
Yes.
This is the impugned judgment, Lordship, in the civil miss appeal number 2 of 2025.
So it was finally heard.
Stay in this place.
But Lordship, before that, Lordship, my learned friends just forget. Let me tell you, Lordship, along with the civil appeal, they have filed an application under Order 41, Rule 5, for stay of the interim order. That order was rejected by the appellate court. IA 2 of 2025. By order dated 10th of February 2025. Page number 485, 486. The same civil judge, senior division has rejected the order 41, rule 5.
Against that, they came to High Court. Legend Gyadi came to High Court.
So there was no stay given. Yes.
No stay given.
No stay given. The matter was finally heard.
Finally, against that, Lordship, they come to the High Court.
That was rejected.
Yes, that was rejected. Lordship will get that order at page 487 to 501. For only 1 year, Lordship, I'll read this 487 to 501.
So that was, against, rejection of stay, they came to the High Court.
Yes.
Then that was at 487 to 501.
Yes. Just a minute. Lordship, get it.
Yes.
And 487 Annex of 4, CRP number 15 of 2025.
Yes.
Lordship, may please come to page 490. 499. Page 490. It is filed by Legend Gyadi. The elected president.
Yes.
Lordship, 7/3/2025 order. Heard Mr. D. Mozumdar, Learned Senior Counsel, assisted by S.K. Deuri, Learned Counsel for the petitioner. For Legend Gyadi. Also heard R. Sonar, Learned Counsel for the respondent. Now, Lordship, please come to page 499. Para 17. Only first 4 lines, Lordship. I will not read the all other
Yes,
thing,
yes.
Lordship. Many things have been argued. So many things has been said. What the court said in paragraph 17. However, it is observed that while passing the injunction order, the learned trial court has discussed 3 golden principles in detail, and the learned appellate court, while rejecting the prayer of the stay, also noted that the trial court had thoroughly considered this principle. I'll not read anything else, Lordship.
Hmm.
While rejecting this revision, the court has come to this. Trial court, appellate court, the court said that the 3 principles thoroughly discussed. Lordship, may please take the paper book 1 now. Lordship, I tried to sort the thing.
No, that's fine. That's fine. Yeah, that's fine. No, I mean, it's just I mean,
Lordship knows that the civil matter sometimes is some.
this court is learning civil matter. I do not know anything about this.
No, Lordship. It's pleasure
Yes.
to.
Page
Lordship, page 178.
one.
The impugn order. Now, Lordship, something unbelievable, Lordship. The judicial order
178, right?
178.
Yes, yes.
When observation by the High Court.
And Lordship, till here, Lordship,
Hmm.
Lordship, here also, Lordship can see page 178. It is the appellant is Legend Gyadi.
Hmm.
Then 1, 2, 3 are the respondent. And all other
Performance.
are performer.
Yes.
Again.
190.
Lordship, may please come to page 190. It is shocking, Lordship, but I have to read. 190.
190.
The same judge who has rejected the 41-5, saying that the trial court has discussed prima facie, trial court has discussed the irreparable loss, balance of convenience. And then High Court has approved.
Correct.
Now, the para 9 at page 190. Para 8. I'll start from para 8. Lordship. Page 190.
Yes.
Heard all the learned counsel, peruse the case record, seen the impugn order dated 28/1/25, passed by the learned civil judge, Junior Division Capital Complex so-and-so, in Mizze case number so-and-so, arising out of title suit number so-and-so, granting temporary injunction in favor of the respondent. Seen that the learned court below has mentioned, applied the 3 golden principle of prima facie case, balance of convenience and irreparable loss in granting the impugned temporary injunction order. Now, it has been, it is to be seen as to whether the said discretion in granting the temporary injunction of the learned court below has been exercised reasonably and in a judicial manner or not. It is observed that it is in the impugned order, the learned civil judge Junior Division UPR has stated that from the perusal of the above, it is evident that there was a specific direction to the respondent number 1 to 9 by the order dated 14/11/2024 regarding the appellants therein to be allowed to contest the election and other party be barred from participating. The report of the official election observer and the order of the Deputy Commissioner and Superintendent of Police makes it evident that the order dated 14/11/2024 was not complied with in toto by the respondent number 1 to 9. The said violation was even after the intervention by the said authority. So from the above, it is crystal clear now that the prima facie case is established in favor of the applicant. Further, it is also stated in the impugned order, all the same time, it is now also aware that the respondent has placed themselves in the way of harm of their own doing. There is a violation of this court order dated 14/11/2024. From the above, it is observed that the learned civil judge Junior UPI in impugned order that is so-and-so stated that the respondent appellant herein have violated another injunction order dated 14/11/2024 of another suit in Mizze case number so-and-so, in order to come to the decision of prima facie case being made out by the appellant respondent herein in order to grant impugned temporary injunction order. In addition, it is seen from order dated 9/12/24 passed by the learned court in so-and-so, that with regard to the allegation of violation of the injunction order dated 14 by the respondent appellant, the said miscellaneous application filed under order 39 rule 2A of 151 CPC is already pending before this court. Now this court is aware of the principle of law that the contemner and violator of an order of a court should not be allowed to enjoy and retain the fruit of the contempt or the violation. However, the fact that the appellant had violated or not the injunction order dated so-and-so has to be decided after conducting a summary trial in the same suit by hearing the other side and recording evidence as the provision order 39 rule 2A by the trial court below. Thus, stating that the injunction order 14/11/2024 is violated by the respondent appellant in the impugned order dated 28/1/2025 would amount to predetermination of the allegation of violation of the said injunction order dated 14/11/24, and additionally coming to a decision that a prima facie case is made out to grant temporary injunction in favor of the applicant respondent herein on the basis of the said predetermination in the considered opinion of this court cannot be considered as just and reasonable. Lordship, this is the height of perversity, Lordship. There should be some height of perversity, Lordship.
SP observer
Now, Lordship, with this, she has vacated, Lordship.
Now we filed the resolution. Then, now before the trial court, Chief Election Commission, the Exonement Committee admitted that yes.
Now there is a subsequent development, Lordship. There is a subsequent big development, Lordship, after this.
So ultimately, that initial order was
vacated.
vacated.
In the last suit, Lordship. This title suit number 21 of 2020.
So which was challenged before this High Court and which
Yes.
was rejected by this court
Yes,
earlier.
yes.
So now that order has been vacated.
Vacated.
Okay.
Okay. Now, Lordship, what happened? But all others, it is there. These all other.
That initial order is there.
Yes, not only initial, the second one also. Initial is already there. Title suit 1 of 2024 is there. Then Lordship, title suit 17 of 24 is also. Then Lordship, all other orders are there. Now Lordship, there is a big subsequent development.
Yes.
Let us, Lordship, in the revision petition, Lordship, here we have filed an additional affidavit. Lordship,
the revision petition that was pending.
Yes. Lordship, now in the paper book itself. No. This case.
What's this case only?
This case only.
You have filed an additional affidavit.
Yes. Lordship, may please come to page 112, the volume 1.
112. Page 100 and?
Please 112. Page 112, my lord.
Yes.
Lordship, get it? In the volume 1.
Yes, I got it. Annexure A1.
Yes. This I have annexed to my additional affidavit.
Yes.
Lordship, this is a written statement filed by defendant number 1 in the title suit number 21 of 2024. The present suit, Lordship, the last suit.
Yes. So they
Did-
filed this written statement.
Yes.
The number one.
Written statement by defendant number one. That
And
is-
defendant number one is the Chief Election Commissioner. All others are they are the appointee of the Chief Election. This polling officer, yeah, all those are they are nobody. They are nobody done. Now they have started shouting Lordship. That's a different matter. But they are nobody in this case.
Respondent number two.
The present respondent number two. He is
Yes, the
the
present respondent
defend-
number two. Yes.
present respondent number two is the defendant number one in the suit.
Hmm.
Now he has filed his written statement, Lordship.
Hmm.
There are 9 and page 150.
Para 9 at page 115.
Para 9.
Para 9 at page 115.
Hmm.
Sixth line, however.
I'll read from the sixth line of para 9, Lordship.
However.
However, Lordship, Lordship get it. However, since the nomination and the scrutiny process were ongoing, the deponent could not implement the order passed by the Honorable Court. Further, the answering defendant stated that the answering defendant being the final authority for the peaceful conduct of the General Conference cum election, the answering defendant was under immense pressure. It is also stated that though unconfirmed, there were reports of fights between various candidates and their supporters, and as such, there was threat to the safety of the defendant as well, deponent as well, if the order dated 14/11/24 was implemented by the deponent. This is an admission, Lordship, first. That situated thus, under the facts and circumstances stated herein above, the answering defendant had to issue the notification dated 16/11/24 by ignoring.
Who's appearing for chief elections?
Soki.
Soki is appearing. Okay. Right.
Then stated on 40 and implemented and
Yes, I've gone through.
that it does. Under the facts and circumstances, the answering defendant had issued the notification that is so and so, and order that is the Honorable Court. Now, para 11, Lordship. Para 11. That as regard the statement made in paragraph 30 of the plain, the answering deponent states that after the voting was completed by the student of the colleges and the university, the deponent held an emergency meeting with the candidate while deciding the voters and the elected from the branch students union on 25/11/2024. That the deponent reiterated that since the team of led by Ray Taha had been recognized by the ANSU president, the denial of voting right to the term of absenteeism led by Ray Taha would have caused serious law and order situation in the election process. That situated thus the deponent in the interest of conduct and completion of the peaceful election denied voting right to Biki Tania and his team, and the faction led by Ray Taha was allowed to cast vote in the 16th General Conference and the list of 54 delegates furnished by Sri Ray Taha was enrolled in serial number 5682 to 5736. That the deponent reiterated that even though this Honorable Court has directed for the participating in voting right to the faction of the Biki Tania, the deponent had to deny the participation to them due to the unprecedented circumstances during the election process. The deponent unconditionally apologized for the denial of the participatory right to the plaintiff applicant, and further apology is tendered for allowing the faction led by Ray Taha to participate and cast their vote in 16th General Conference come election of Anshu.
So he has basically admitted that he has violated the code.
Now, Lordship, some of the council is trying some mathematics, permutation, combination, that if you get 51, they are doing mathematics now in the board, that if you get 51, you will get 108. All this mathematics started by some officers, lower level officer, not the Chief Election Commissioner. The person who was appointed by the Chief Election Commissioner, they are arguing before the court for last 10 days.
I mean, this is on record. I mean,
Yes, yes.
No, their constitution.
Yes, yes.
Their
Constitution is there, Lordship, on the record. Yes.
In the paper.
In the paper book, in the main book, I'll show Lordship.
And just page number.
Page 295 probably, Lordship.
Second paper.
In the second paper book. And Lordship, my client who lose his right, his term will come again after 17 years. This is a dangerous constitution, Lordship. It's a area-wise, Lordship, zonal-wise.
Why 17 years?
There is a roster type of thing, Lordship.
Okay. But election is
that the
every 3 years.
president will come from
But election is every 3 years. But
no,
he cannot-
every 3 years that they can join in the participate all that, but they cannot participate as president, office bearer.
Okay.
The village wise, zone wise, elect this constitution is very specific, my lord. So my client's right will come after 17 years, my lord.
Page 325.
Page 325, Lordship.
21-1-2.
No, constitution can start condition.
290.
Page
It
325.
is page 295, Lordship.
295. Okay.
Relevant is 320.
No, I mean, since you have submitted that, like now they are raising lot many issues, other polling officers and all, their powers and all these things, where are they?
No, nothing, Lordship. No,
Nothing is
they're not there.
Correct.
And they're not there in the
Chief
constitution.
election commissioners.
It is there.
Where is that?
Yes.
Phase?
325.
Phase 320?
325.
325. Okay. So, okay, so in constitution, only chief election commissioner.
Yes, yes, it is there. Lordship. 325.
ठीक है.
Roman 3.
21-1, 2 and 3.
Article 21,
हाँ,
the election commission,
okay.
2 and 3. The chief election commissioner shall be the head of the election commission.
Correct. That will be fine. I'll take it out.
Only.
After this,
And one is this election commission, only look at to one, Lordship. What constitute election commission? The president shall constitute the election commission, consist of the chief election commissioner, the returning officer, and the presiding officer, polling officer, and other member as may be required, but not exceeding 8 members. This 2 is very Lordship, it is necessary, Lordship. The chief election commissioner shall be the head of the election commission panel and shall ensure the smooth electioning process and completion of all electioning process, including declaration of result and stipulated time. So, Lordship, my term and all that will come after 17 years. It is there in the constitution itself.
Page 331.
331, Lordship. It started at page 330, but my point is at page 331, Lordship.
Article 23. Rotation.
Lordship, Lordship, may please come to page 330.
the rotation of central.
Yes. Then, Lordship, 331.
Rotation tenure. My East Tamil.
I am from East Kameng, Lordship.
So area wise, they have given made a roster.
But who has made this, I do not know, Lordship. This is something very critical, Lordship.
So one area is debarred
Yes.
from, doing anything.
So if they will get now, after 17 years, they will come again. And now they will continue. Now they will continue. And after the court's order, Lordship, now they are continuing. They are using seal. Everything they are doing. So if the injunction is not there, Lordship, this is only 3 years term. my whole thing
No,
will
no,
go.
now, I mean, this, after this, I mean, I mean, when this order was passed, that was on
28th of January, 28/1/25.
28/1/20.
That is page 193 to 196. And Lordship knows the power of the appellate court. Now, after the Supreme Court in all these judgment, in the trial court judgment, you cannot substitute your view. If the trial court has decided, now you cannot substitute your view. Lordship, in this case, I can show many things, but the Lordship, let us go cut short, Lordship, because I know. And the enrolling committee, they himself has admitted, Lordship. That is at page 153, Lordship. Lordship will take note of that also. It is the Chief Election Commissioner, then the enrolling committee, the main body for enrolling the name. And these are all on affidavit, Lordship. It is not that someone has said somewhere, Lordship, is not that. The Chief Election Commission has said, now this is the enrolling committee at page 153. Paper book 1. The same thing the Chief Election Commission has said, like the same thing, Lordship, that they were been threatened and all that.
Their personal problems.
Yes, same thing, Lordship. Same thing. That they were.
Anything else?
Yes, Lordship, on facts, Lordship, this is, I think this is, Lordship, regarding the power of the appellate court and.
So, you are seeking something in interim.
Final disposal. It is for final disposal, Lordship.
Disposal only, no, isn't it?
Yes, it is for final disposal. On the last date also, before also, Lordship, that in the admissions, the matter will be disposed of, Lordship.
Correct. See, any judicial pronouncement, any issues?
Yes.
Yeah.
In fact, Lordship, I have given a written argument long back. Once the court heard the matter for a long time.
It is there.
And yes, it is there. Court has recorded in this order that the written argument I kept in the file.
Okay.
Because after hearing long time, he has come that I am a local judge. It
I
will
will
not.
check, it is there.
Yes, yes.
You have checked?
No, if I'll check, Lordship, if not there, I'll give it one.
No, if it is there, it's fine.
Yes, I'll check again, Lordship.
Then sometimes what happens if it is there, I mean, somebody says.
If it is
that,
not
like,
there, I'll give it.
I mean, it is there. Then like, take the file back, then if it's not there, then it becomes.
No, I'll give it again, see if it is. He'll check.
So I don't want to take that risk actually.
Yes. Lordship, it is para 36 to 41.
I say it's on which point?
It is 2024 11 SCC.
Correct. Which point is this?
It is the power of the appellate court, Lordship. Lordship can take this, Lordship. I'll not give all this judgment, Lordship. I'll not give all this judgment because I know proposition and all that I have written separately, Lordship. This 2024 11 SCC page 351. I'll just read paragraph 36 to 41.
Sure.
Lordship.
Para 36.
Yes. The wrong finding to stem out on a complete misreading of the evidence, or it should be based only on conjecture and surmising. Safest approach on the perversity is the classic approaches on the reasonable man, inference on the fact. To him, if the conclusion on the fact in evidence made by the court below is possible, there is no perversity. If not, the finding is perverse, inadequacy of evidence or a difference reading of evidence is not perversity. See so-and-so versus so-and-so. Para 37, that in light of the aforesaid settled proposition of law, we are of the clear view that the fact of the present case, the High Court overstepped its appellate jurisdiction under Order 43 and substituted its own view for the one taken by the trial court without giving any categorical finding as to why the order of the trial court be said to suffer from perversity, capriciousness, and arbitrariness. In my appellate court judgment, not a single word is there, Lordship. That it is, Lordship, that there is perversity, that there is capriciousness, that there is any arbitrariness, and mala fide, or having been passed in ignorance of the settled principle governing the grant of injunction under Order 39 CPC. It appears from the reading of the impugned order that the weight of the High Court in setting aside the order of the trial court was the existence of pending litigation between the contesting parties and the alleged misuse of the political power by the plaintiff in creating hurdle to the defendant in exercise of their lawful right. The High Court failed to point out any perversity on the order of the trial court, which occasioned in it to set aside the grant of injunction. We are of the view that the High Court ought to have limited itself for adjudicating the correctness of the order of the trial court on the settled principle of law and should not have taken into consideration any other extraneous matter, more particularly when the suit still pending for adjudication on merit before the trial court, as in our case. We are informed that the High Court allowed the appeal, and before the court granted the interim relief, the defendant had transferred the suit property during the pendency of the present appeal. Here in this case, Lordship, they have taken this when there is a specific direction not to take oath. Deputy Commissioner, SP, everyone has been ousted from the office and took the oath. Then Lordship 41, Lordship 40 also, we'd like to, the Lordship 40 and 41, Lordship can read instead of subject in order of the trial court, the right of degree. Lordship, it is already there, Lordship.
It's 51. 51
Now, Lordship, why in this case, Lordship, I am saying, Lordship, a proposition is started from the day one. I am saying, Lordship, I have argued this case many a time before many judges. Only one thing, there is a mathematics that 51, 64, 108, that are mathematics. Mathematics not by the counsel for the Lizen-Gadi. It's not by the counsel for the Lizen-Gadi. Some other counsel who has nothing to do. He's a polling officer, someone, they have started this argument, Lordship. It is not Lizen-Gadi's counsel. He started that argument that this is the proposition, that this is 54, this is 56. All this, Lordship, I'm not on mathematics here. It's a case of electoral fraud, Lordship. Electoral fraud. It is nothing else. It is a fraud.
Sharma. Hipala sab DS.
Electoral fraud. There are 14.
This is regarding electoral fraud, Lordship.
Doesn't matter
if the electoral roll are incorrect, Lordship, as in our case, it is an admitted position, Lordship, after 2 affidavits by the election commissioner and both the enrollment committee. It is an admitted position now. Nobody can change it. It is on affidavit that electoral roll is not correct. After that, Lordship, doing mathematics and there is no point. 108, showing some judgment from the Representation of People Act, Lordship, that the Supreme Court has decided in Representation of People Act cases that if the election is held, nobody can interfere and all that. Para 12, Lordship. Page 6, para 12.
Yes.
It is of the essence of this election that the proper electoral roll should be maintained, and in order that a proper electoral roll should be maintained, it is necessary that after the preparation of the electoral roll, opportunity should be given to the party concerned to scrutinize whether the person enrolled as an electoral process the requisite qualification. Opportunity should also be given for the revision of the electoral roll and for the adjudication of the claim to be enrolled therein and entertaining the objection of such enrollment. Unless this is done, the entire obligation cast upon the authorities holding the election is not discharged, and the election held on such imperfect electoral roll would acquire no validity and would be liable to be challenged at the instance of the parties concerned. It was our opinion, therefore, necessary for the Chief Election Commissioner to frame rule in this behalf, and insofar as the rule which was thus framed omitted this provision, they were defective.
Correct.
And Lordship, the para 14, the Supreme Court has said very specific. What is argued for the last 4 or 5 days on various days, the Supreme Court is very clear on this para 14. In the view which we hold, it is not necessary to consider whether the event of the inconsistency between the Section 30 subsection 2 and the regulation of the rule framed by the Chief Commissioner and exercise of the power conferred under Section 43 of the regulation, the section will prevail in the rule. Suffice is to say that the electoral roll of Ajmer municipality, which was authenticated and published by the Chief Commissioner and so, was not in conformity with the provisions of so, and the relevant provisions of the regulation could not form the basis of a valid election to be held for the so committee. It's not a valid election even, Lordship. So in my case, Lordship, after that two affidavit, Lordship, that this whole thing is illegal, there is nothing to hear, Lordship.
They go to subsequent site.
Now, the one argument will make, Lordship, all these affidavit and is a subsequent fact.
Which is subsequent fact?
This affidavit and this filed by the all electoral roll officers here.
But facts are not subsequent.
No, facts are not subsequent.
Then what is the...
No, that is argued law.
No, that's what I'll have to ask them how it becomes subsequent.
In the course of proceedings in the
Now it is in the revision it is filed. So it is argued, Lordship, that this is a subsequent thought and the subsequently filed and all that.
Para 4.
during revision.
And during the revision itself, Lordship, this has happened, Lordship, in the trial court. So we being on the record, Lordship, by filing an...
This case, para 4.
Yes, Lordship, para 4. It is the para 4. This is the base judgment for subsequent event, Lordship, para 4. It is 75 1 SCC page 770, Lordship. And I will not take much time, Lordship.
Yes.
It took court.
This is the last judgment.
This is the last judgment, Lordship. I'm not sure. So, one thing is heard, Lordship, every time, Lordship, before this court. Let the earlier court's order was violated. So you cannot file a subsequent suit, taking that as a cause of action and all that. And the subsequent suit injunction cannot be granted. We are at liberty to violate the court's order. You can do anything and everything. You are barred to file a subsequent suit. That was argued many a time. You are barred to file a subsequent suit. Because earlier what happened, earlier that we have violated. Now you file a order 39, rule 1 and rule 2A, and wait what the order 39, rule 2A will say. Then you take in the meantime it will continue. So this is direct on that, Lordship. This judgment from our High Court, Lordship. The facts in this case, Lordship, this Lordship 1991 2GLR page 153, the fact is very clear. By the declarative decree in suit number 1, the Ann's mother was declared to have a right, title and interest over a property and purposeful injunction was granted in our favor and against the defendant K, directing K not to disturb N's mother possession over the property. N's mother dies. Thereafter, K breaches the perpetual injunction and encroaches upon the properties and files suit 2 for a mandatory injunction under section 39 of the Specific Relief Act 1963 against K, seeking his removal from the property. Objection is raised against the mentality of the suit 2 to the effect that the actual remedy lies under Order 39 Rule 2A, as in our case, Lordship, time and again. That is the argument. Order 39 Rule 2A is pending. You wait and see what will happen there. Till then, no court can do anything. Now, Lordship, the judgment, Lordship, please, Lordship may come to para 24. Because so that this thing will not argue, that is why I am showing this, Lordship. The Delhi Development Authority, Skipper Construction, all these are there, Lordship. That nobody should be allowed to reap the fruit. Violators cannot reap the fruit, Lordship. They are not only the violator, Lordship, it's jungle law, Lordship. The Calcutta High Court in the division bench judgment has specifically in the similar facts, Lordship. In that INTUC election, Lordship, Calcutta High Court said, what is going on? This is jungle law. Para 24, Lordship, page 165.
Yes, yes.
On consideration of the fact of the present case, in the light of the principle emerging from the foregoing discussion, I am of the opinion that the first appellate court was not correct in holding that the plaintiff appellant lost their right and interest in the suit land on the death of their mother, in whose name the annual patta in respect of thereof stood. Besides, the respondent has no right or the title in the suit land. Admittedly, the plaintiff appellant were the successor in interest of their mother, who was the annual patta holder. The earlier suit filed by their mother had been decreed in her favor, and the delivery of possession of the suit land had been given to them in execution of decree, as their mother had died in the meantime. There is enough evidence on record to prove delivery of possession. The respondents were also restrained by issue of perpetual injunction not to disturb the possession of the plaintiff appellant, as in our case, Lordship. Under the circumstances, the respondent has no legal justification to dispossess the appellant from the said land in the violation of the perpetual injunction. Even if the respondent got the right on the basis of the event subsequent to the decree of the court, the only course open to them was to enforce their right by a suit which they did not do. It is therefore a clear case of acting in contravention of the perpetual injunction. Therefore, the next question that arises for consideration as to whether the mandatory injunction can be granted under Section 39 of the Specific Relief Act. Under Section 39, mandatory injunction is quoted, Lordship. The fact of the case and the relief sought for in the instant case may be scrutinized in the light of the requirement of the Section 39 set out above. The suit which was given rise in the appeal is only for getting relief awarded in the earlier suit, as in our case, Lordship. Exactly in our fact, Lordship. This is in the fact of the suit for possession, though caused in terms of the suit for the mandatory injunction. The earlier suit of the plaintiff was decreed in their favor and recovery of possession from the defendant was ordered. Perpetual injunction was not granted, directing the defendant not to disturb the possession of the plaintiff. Decree was executed and delivery of possession was given to the plaintiff. The perpetual injunction was also duly served on the defendant. The defendant thus had an obligation not to disturb the possession of the plaintiff. The defendant, however, committed a breach of the obligation. The court, under such circumstances, has definitely the power of grant mandatory injunction under Order 39 of the Specific Relief Act. The existence of a remedy under Order 39 Rule 2A of the Civil Procedure Code, in my opinion, does not stand on the way of the party approaching the court for a mandatory injunction. Order 39 Rule 2A, which deals with the consequence of the disobedience of the breach of injunction, provides for a penalty and disobedience. The property of a person guilty of such a disobedience may be attached, and such person may also be detained in civil prison for a period up to 3 months. But under the provisions of this code, cannot give an immediate relief to the party aggrieved by the breach of the injunction. There are cases where the court have invoked their inherent power in the case of violation of inherent interim injunction and granted connection to a
Granted temporary.
yes, the temporary mandatory injunction. Reference may be made by the connection to a decision of so-and-so in a suit filed by a plaintiff declaration his tenancy for a permanent injunction restraining the defendant from interfering with the possession of the premises. An interim injunction be granted, restraining the defendant from interfering with the possession of the plaintiff. The defendant has forcibly dispossessed the plaintiff and took possession thereof in utter violation of the interim injunction. The Calcutta High Court took the view that the opposite party is asked to pursue the remedy under Order 39 Rule 2A. It will be doing a great injustice to him, inasmuch as under the said provision, the court cannot get immediate relief to the opposite party. It was held that in a case like this, where restoring things to their former condition is the only remedy, the court has to take steps for the purpose of exercise of inherent power.
Yes, sir.
In view of this finding, Lordship. This is that, so that should be the spirit, Lordship. And so, Lordship, this Calcutta High Court I am giving, I am not reading, it's only for that purpose. The Calcutta, this division must say that this is jungle law if you are doing all this. If the court's order are violated like this, and if the subsequent court cannot grant an order, there's something jungle law going on. It's a prima facie, Lordship. So, it's a right of reply, Lordship will give. And my only thing, Lordship, the first volume to Jason Agor.
So you I mean, after their submissions, you would like to reply?
Only one thing, Lordship, I want to, only one thing, Lordship. Because that day, after the court has gone, Lordship, I, from the Vakalatnama, what I have seen, who is appearing for whom? Lordship, in the para 3 of the main volume, Lordship, page 3 of the main volume, Lordship, of the revision petition,
Okay,
Lordship.
so here, okay.
Here, Lordship will not get. Because, Lordship, while the other side started arguing, court to appreciate, Lordship, who is arguing for whom and what he is arguing. What is his right for argument? Locus to argue all this.
So what do you want
At
to
that page 3, Lordship, the name of the respondents are there, Lordship. The page 3.
Yes.
The number 1 is Legend Gyadi.
He is the
Learned Council is K. Tama. Huh? Yes. He is the Learned Council is K. Tama. He is appearing for Legend Gyadi. For 2, it is the D. Shoki. Learned Council is D. Shoki. It is not only 2, 6 to 10 also, na? Huh? Yes.
2 and 6 to 10.
Yes.
Okay.
Lordship, he is appearing for 2 and 6 to 10. The Learned Council, Mr. D. Shoki. Then 3 is D. Taba. Learned Council, T. Taba. As per Vakalatnama, Lordship.
Okay.
Then 4 and 5, it is very important, Lordship. It is presiding officer. 4 is presiding officer and 5 is polling officer. Is the Learned Senior Council, Mr. D. Majumdar, is then assisted by Mr. Deuri. They are the presiding officer and pooling officer.
Who are in the civil appeal, they are pro forma respondents.
And in the appeal, and then they have not filed any appeal, they have not done anything, and they are in the pro forma respondent only. And in the suit. In the suit and appeal, they are pro forma. Here, Lordship, at the time of filing the revision, they have just forgot to write the pro forma, so they become the main respondent. But all other, they have not filed appeal. Nowhere. Only Lizen Getty has filed appeal, Lordship. No one else. Then, Lordship, for 6 to 10, Mr. D. Soki, Learned Council, he appeared, Lordship. That much, Lordship. And all the council, all of them has appeared, all of them has filed Bhagalatnama, Lordship. That's my point, Lordship.
So you didn't have any grievance against other people also?
No.
I mean, only thing is that like, I mean, there is some mistake in this thing, making parties.
Yes.
The pro forma and all.
Yes, and the Lizen Getty and me, Lordship, is my fight.
But you have made respond, all the people responded.
Lordship, that I cannot say, because, but the Lordship, there is no appeal filed by them.
Okay.
It is in the injunction also, their pro forma, in the appeal also, title appeal, their pro forma. That's an admitted position.
That I have seen everywhere they are pro forma only.
Yes,
only thing is that now here they have become main respondents.
Yes, Lord.
Main respondents will depend upon the, contents, allegations, how they are grieved, all factors.
Yes.
And then it will be decided. I mean,
Yes.
nomenclature
Yes.
will not do. If there is no, allegations against them, there is no grievance.
That's the point. That's the point.
Then where is
Lordship.
the
That's my point, Lordship. That is why I'm showing this. I'm grateful, Lordship. That's my point, Lordship.
Yes.
My Lord, may it please your Lordship. My Lord, I have instruction to appear for respondent number 1, who is the returned candidate today, my Lord. And I'll be assisted by Mr. Tama, who is there, my Lord. My Lord, I'll be taking at least 1 hour. My learned friend has taken 1.5 hours time. So at least 1 hour time will be required. My Lord, should I start or tomorrow morning?
And Mr. Mojumdar will be appearing for?
Respondent number 1, my Lord.
One in?
Only respondent number 1.
But you were appearing for somebody else earlier?
Earlier, I had instruction to appear for. So, my Lord, they are saying that main respondent is respondent number 1.
All the order, it is for respondent number all 3 and 4.
No, correct.
But
Now,
today
not
I
3
am-
or 4. The 3 or
My
4,
Lord,
you are
I
not
have-
appearing now.
My learned friend, Mr. Deuri, possibly will appear for them.
But not in addition to 3 and 4, you are appearing 1. It's not like that. You are appearing only for 1 now.
My Lord, I am appearing today only for respondent number 1.
Only for 1.
My Lord.
Okay.
My Lord, should I start now or tomorrow morning?
No, I think we'll continue tomorrow. I mean, today, Mr. Sharma, you are there?
Yes, I'm there.
So tomorrow we'll do it. I mean,
My
today.
Lord, Lordship will kindly give us at the on top of the list so that I can finish it. My Lord.
Yes, I have no problem. I'm here, Lordship. I want to finish it up, Lordship.
Now, only thing is that like, if there are some bail matters, the bail matters will have to be
Soon
taken
after
up.
the bail matters, my Lord. Naturally,
Yes,
my Lord.
yes,
Those bail
after the
matters are
matters,
urgent.
Necessarily, Lordship. Bail matters, Lordship.
If there are some bail matters, then I'll take up those matters.
Yes.
Then we'll take
My
it
Lord,
up.
My Lord, tomorrow will there be a division bench also?
Usually we have division benches, but I'm not sure because I haven't seen the cause list as yet.
No, whatever, Lordship, even if the division bench is there, even if the bail matters are there, whatever, Lordship, tomorrow, Lordship.
Tomorrow we'll take it up. Tomorrow we'll take it up.
Whatever, Lordship, it is there or
Mr.
not.
Majumdar can instruct your junior to keep a track. I mean, then we'll take it up.
My Lord.
We'll take it up.
Very well, very well.
Heard Mr. S. Sharma, the learned senior counsel, assisted by Gautam. Mr. Gautam, the learned counsel appearing for the petitioners. Then Mr. D. Majumdar, the learned senior counsel, appearing for respondent number 1. Then Mr. D. Soki for. And what about you?
I'll be assisting.
Mr. Majumdar. Will be assisted by, take his name. And what about you?
4 and 5.
4 and 5. Your name, I just forgot.
SK Deuri.
Oh, SK Deuri. I mean, SK Deuri is appearing for respondent 4 and 5. Anybody else is appearing in the matter? No.
No, D. Soki for the all others, Lordship. 2 and 6 to 10, Lordship.
So matter
My-
remain part heard. Let the matter be listed tomorrow.
My,
Tomorrow, we'll not mention the top of the list.
My lord.
At
We'll
least
take it up. We'll take
soon after the bail matters, my lord.
it up.
Yes,
We'll take it up after
Bail matters.
Bail matters.
I'm grateful.
Obliged.
Soon after bail matters. Yes.
I'm good.
Item number 7.
There's some matter. এটা মিটার নলে অল হয়ে গেল এটা আর বলে সময় নাই কালি কান থই না এটা নলে আছে
7 alert. 7.
তুই 7 টু কার সাপোজ মানে মানে তুমি কেটা ম্যাটার স্যার no 7 to car 7 you are there
Yes, my lord.
who is appealing for that
The petitioner side, my lord, they are supposed to file their affidavit, additional affidavit to bring it.
none appears for the petitioner where the matter was called for though Mr. T8 the learned APP is present let the matter be fixed when
My lord, after break, my lord.
let the matter be fixed on 9th of January.
Okay, madam. Oblige.
Item number 26.
Mr. Patin, today it will not be possible. So we'll do it some other time. So when do you want it?
28 January.
20th of January?
Yes, madam.
Okay, Mr. M. Patin, the learned senior counsel, assisted by his son probably. What is his name? M. Patin. And who else is appearing? Mr. Kato is appearing?
Respondent number 1, madam.
Mr. Kato is appearing for respondent number
I am on
1.
3, Lordship.
Mr. Goswami is for respondent number 3.
I'm for the statement.
Mr. T8 for APP for the state. Due to paucity of time, the matter could not be taken up today. Let the matter on agreement of the council appearing for the respective parties, let the matter be fixed on when 20th.
Top of the list, Lordship.
29. No, senior counsel is asking.
Yes, he agreed.
Okay. 29.
28, 29, the other, I have discussed with the other council, madam.
29.
28,
No, all the councils are there. You can discuss here only and then decide.
Very difficult. 29.
When Goswami is fine, 29.
It's 29. I agree.
29.
But it may be listed for top of the list.
No, that cannot be done. That will be difficult. So, so many other matters come. Goswami, I mean, we'll accommodate, right? But listing is difficult.
Lordship.
So 29 we have fixed. 29.
Lordship.
29.
Attend.